welcome back to the April 26th meeting of the Board of Oil, Gas, and Mining. We are on the record. I'd like to start with docket number 2023-011, cause number 132-13, and note that this matter has been withdrawn without prejudice. So we can move on to the second item, I believe, which is docket number 2023-014, cause number 470-08, in the matter of the request for agency action of Uintah Wax Operating LLC for an order establishing overlapping 25 60-acre or substantially equivalent drilling units for the production of oil, gas, and associated hydrocarbons from the Lower Green River Formation through drilling unit boundary long lateral horizontal wells. I will now ask for appearance of counsel.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner Uintah Wax Operating LLC.
Trevor Gruelle with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Thank you. Over to you, Mr. McDonald.
Thank you, Mr. Chairman. The IT people, do we have the remote witnesses available on the screen?
Yes, we'll be bringing them up now.
All right, thank you. There we go. Mr. Chairman, members of the board, with me today, appearing virtually, thanks to the board's consideration to have them appear virtually, and their order are Mr. Zachary Archer, who's the senior landman of Uintah Wax LLC. Mr. Archer, would you please wave on the screen so they know who you are? And Mr. Shay Atkins, who is the vice president of development of Finley Resources, Inc. and Uintah Wax LLC. Both share duties with the petitioner, and I would ask that they be sworn in at this time.
I'll swear you both concurrently. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Yes.
Okay, good. Audio is very good this time, too. Thank you. Mr. Chairman, the resumes of the witnesses were collectively submitted as Exhibit A for this cause. If asked, each will confirm the information reflected in their respective resumes is true and correct. Mr. Archer will be a fact witness only. Mr. Atkins has previously been recognized as an expert in geology by the board on several occasions. However, based on his extensive experience as reflected in his resume and appearances before the board, and presuming that the division has no objection, I'm going to request that he be recognized as an expert in Uintah Basin long lateral horizontal well development for purposes of this cause.
Division, any concerns?
No objection.
Board, any concerns? Seeing none, he is recognized.
Thank you. And as always, Mr. Chairman, I'm going to confirm that I'll be moving for admission of the exhibits at the end of our presentation in chief.
Perfect. Thank you.
Thank you. Members of the board, Uintah Wax is before you today seeking establishment of two internal drilling unit boundary well drilling units comprised of sections 1 and 12 of Township 4 South, Range 1 West, and sections 6 and 7 of Township 4 South and 1 East, and of sections 5 through 8 of Township 4 South, Range 1 East in Uintah County, respectively. We're asking to allow up to 6 stacked drilling unit boundary wells, similar to what the board has previously authorized in this area of the Uintah Basin, including the board's order entered in cause number 470-06 last August. Stand-up drilling units comprised of sections 1 and 12, sections 5 and 8, and sections 6 and 7, respectively, were previously established for Lower Green River Wasatch production under the board's 139-150 order. The 159-150 order was later modified by the board's order entered in cause number 600-03 to reduce the north-south or the heel-toe setbacks to 100 feet as relating to these lands. True and correct copies of the 139-150, the 600-03, and the 470-06 orders were collectively submitted as Exhibit B in this cause. There are already producing long lateral horizontal wells on each of the existing two-sectional drilling units, which have resulted in conversion under the 139-150 order. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 53B, and 40-6-6. Notice was sent via regular mail to all production interest owners in the requested drilling units, and to the Bureau of Indian Affairs and the Bureau of Land Management, being the governmental agencies having oil and gas jurisdiction over many of the lands. The mailings were sent to these parties at their last addresses disclosed by the relevant BIA, BLM, and Uintah County Realty records. The record will also reflect that notice was duly published in the Salt Lake Tribune on April 2nd, 2023, in the Uintah Basin Standard and Vernal Express on April 5th, 2023, and in the Deseret News on April 7th, 2023. Stanley Holmes filed a, quote, public comment email outlining concerns over air quality issues and questioning the profitability of Uintah Wax Operating's requested relief. However, air quality issues are addressed by the Department of Air Quality, not the board, and there is an element of air quality in the APD review. Furthermore, as the testimony will reflect, the oil and gas in the subject lands is tribally owned, bringing into question Mr. Holmes' standing to even participate in the hearing. We have no objection if Mr. Holmes is here to admission of that letter as public commentary, but with the understanding that it would not be given any evidentiary weight. The Division of Oil, Gas, and Mining filed a response on April 19th, 2023, expressing non-opposition to the request for agency action, presuming Uintah Wax meets its required burden of proof by providing sufficient evidence justifying the drilling of more than one well in the drilling unit without committing waste. As today's testimony will reflect, these conditions are met. No other objections or responses were received, and with that, I'll commence my examination of Mr. Archer.
I'm sorry, could you repeat that?
I said there was no other objections received. I was going to start with our examination, Mr. Archer, if your board's
Please
ready.
proceed.
Okay, thank you.
I'll pay better attention next time.
You need to have your lawyer stop bugging you, right? Mr. Archer, would you please state your name and business address for the record?
It's Uintah Wax LLC, 5128 Apache Plume Road, Suite 300, Fort Worth, Texas 76109.
And what is your current position with Uintah Wax LLC?
I'm a senior landman for Uintah Wax LLC with supervision over the area at hand.
For the record, would you please state the corporate and bonding status of Uintah Wax Operating LLC?
Yes, Uintah Wax Operating is a Delaware limited liability company in good standing with its principal place of business in Fort Worth, Texas. It is the successor by name change to CH4 Finley Operating LLC as of August 1st, 2021. Uintah Wax Operating is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. And Uintah Wax Operating is the designated operator of Uintah Wax LLC.
Turning your attention to what have now been marked as exhibits C through H for purposes of this cause. They're shown on the PowerPoint, and I presume you have a copy of them in front of you. Do you recognize these exhibits?
Yes, these are all the exhibits for the application lands.
Okay, and these were prepared by you or Uintah Wax personnel with your review and input?
Yes, sir.
Okay, turning your attention to Exhibit C, would you please explain what this shows?
So this is the regional locator map. It is the land subject to this RAA and located about 6 miles south of Ballard.
Turning your attention now to Exhibit D, would you please explain what this shows?
So this is the application lands. It's a scaled-in version of the map. Of this map is depicting the 3 existing 2-sectional stand-up DSUs.
All right. Would you explain what is the oil and gas ownership in these lands?
Yes, this is 100% tribally owned. They're all subject to existing BIA leases and the Tribal Exploration and Development Agreement, under which Uintah Wax is the sole lessee and working interest owner.
Now turning your attention to Exhibit E, would you please explain what this shows?
Okay, this is the applicable spacing orders for this area for the application lands. The map includes the application lands and further identifies all existing spacing orders. The first one, the 139-150 order, established the 2-sectional stand-up drilling units for the lower Green River Wasatch, and then the 603 modified for the heel and toe to reduce the setbacks to 100 feet.
Now turning your attention to Exhibit F, would you please explain what this shows?
This is a map showing the applicable lands and identifies all the existing long lateral horizontal wells located within the subject lands. There are 3 existing long lateral horizontal wells on each of the DSUs, comprised of sections 1 and 12 and 6 and 7 and 5 and 6. And all were drilled pursuant to Board Order 139-150 and as modified.
All right, just for clarification, there's one well on the drilling unit comprised of sections 5 and 8, correct?
Correct.
Okay. There's also a green dot shown in section 8. Can you address that?
Yes, there is one vertical well in Section 8 pursuant to Order 139-150. Production allocation conversion is applicable for that well and to sections 5 and the sections 5 and 8 DSU basis as of first production of the month, as of for the first month following first production from the long lateral horizontal well.
So in summary, each of the existing 2-sectional drilling units are already in producing status by a long lateral horizontal well, and conversions already occurred. Is that correct?
Sure.
Okay, now turning your attention to Exhibit G, would you please explain what this shows?
So Exhibit G is a map that depicts the requested drilling units. Both of the requested drilling unit boundary well DSUs are internal, meaning the drilling unit boundary well would be drilled within the 100-foot window on either side of the section of the boundary well section lines, being sections 1 and 12, 6 and 7, and then 6 and 7, and 5 and 8.
All right, would you please, for the record, outline what are the current certification practices with respect to long lateral horizontal wells?
We certified to the division that with our long lateral horizontal well bores will be cemented and cased to the productive intervals within the 100-foot setbacks. We also certified to the division that Uintah Wax Operating has obtained all requisite surface and subsurface consents and authorizations for off-drilling unit of the long lateral horizontal wells to drill through and drill to the unit boundary wells when applicable, and or we will have all surface consents prior to the operations being conducted.
Right, now turning your attention. Oh, go ahead, I'm sorry.
I was going to say the last statement I was going to say is under long lateral horizontal orders, Uintah Wax has requested the same DSU process to be adopted here as to the new drilling unit boundary well DSUs.
Okay, now turning your attention to Exhibit H, would you please explain what this shows?
So Exhibit H is a plat reflecting the notification areas where notice was provided. This plat illustrates all production interest owners within the subject lands. Since these are internal drilling unit boundary wells, DSUs with no modification of the heel or toe, no other parties have legally affected interests.
All right, I'm going to ask you to have in front of you if you're the certificate of mailing, which is a pleading that was prepared by my office. Do you have a copy of that in front of you?
Yes, sir.
Do you recognize the names and the parties that are shown on that?
Yes, sir, I do.
Who are those parties?
It's all the production interest owners within the notification area as identified on this Exhibit H, on the previous Exhibit H.
And how were those parties determined? What records were searched?
They were searched from our internal records, title opinions, county records, and either through our office or through our broker service.
All right. Members of the board, Exhibit Z, which was submitted, reflects that all those parties did receive a copy of the request for agency action. With that, Mr. Chairman, that concludes my examination of Mr. Archer.
Thank you. Division, any questions for this witness?
No questions for this witness.
Board, any questions for this witness? Yes, Mr. Moon.
So I just need my memory refreshed. With other 2560 requests, have they been conversion to a 2560 or overlapping? For example, Uintah's 2560s.
If I could answer that,
Yeah.
the 139-150 order actually was entered or petitioned by Uintah, so that is a conversion situation. Mr. Archer, do you want to address how Uintah Wax acquired the interest from Uintah shortly?
So we didn't acquire for this area we've done trade. So we had operated and non-operated position where Uintah was the majority operator. We've done different trades with them where we became the majority interest in these DSUs and conveyed our non-op position in other areas. So that's how we gained the balance of these 3 DSUs to become the 100% operator here.
So that's why that vertical well converted versus overlapping, which
Correct.
historically, the Crescent Point, Uintah Wax is overlapping.
Correct, but because they acquired the interest from Ovintiv, who had entered this order, they're following that order.
Okay. And then in the majority of our 2560s that we've done have been conversions, correct? Or have they been overlapping?
It's been a mix.
A mix, okay. Okay. Just thinking about horizontal rulemaking and if there's some standardization, but that's a big difference between different parts of the field where we have overlapping and conversions going on, so even with the 2560. So, okay, I just trying to remember that. Okay.
Any other questions from the board? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Atkins. Mr. Atkins, would you please state your name and business address for the record?
My name is Shay Atkins, Uintah Wax LLC at 5128 Apache Plume Road, Suite 300 in Fort Worth, Texas, 76109.
And what is your current position with Uintah Wax?
My position is VP of Development for Finley Resources and Uintah Wax with supervision over the area at issue.
And again, Uintah Wax operating is the operating entity for Uintah Wax?
Yes, sir, correct.
Okay, I'm going to show you what have been marked as Exhibits I and J for purposes of this hearing. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or Uintah Wax personnel with your review and input?
Yes, they were.
Okay, turning your attention to Exhibit I, would you please explain what this represents and its significance to your request?
Exhibit I is an illustration showing how, given existing frac orientation and half lengths and setbacks under the 139-150 order, resources would be unrecovered and thereby committing waste without a drilling unit boundary well. The board has recognized the need for such wells on many occasions, including other Uintah Wax operated DSUs in the area, such as 470-06.
All right, and under the 139-150 order, the existing long lateral horizontal wells were drilled at a 560-foot setback. Is that correct? On these
That is correct.
particular lands? Okay, thank you.
Yes, and those are illustrated with the yellow existing long lateral wells shown on the diagram.
All right, now turning your attention to Exhibit J, again, would you please explain what this shows and its significance to your request?
Okay, Exhibit J, on the right side of Exhibit J is an example of a multi-zone full development whereby DSU boundary wells are a critical piece to ensure that all recovery of all resource in these units to prevent waste. And so with that goal, the goal in mind, our development is to provide the optimal well spacing and density and to prevent waste while also creating the highest net present value, as you can see on the chart on the left. And so at the end of the day, the goal is to optimally space everything so that nothing's being left behind, which includes the DSU boundary wells.
And again, how many wells are you seeking to drill along the drilling unit boundary?
We're seeking to drill up to 6.
All right, thank you. All right, in your expert opinion then, are the drilling unit boundary wells necessary to recover resources that would otherwise be left in the ground, thereby committing waste?
Yes, they are.
It is also your expert opinion, expert opinion that such wells will allow greater recovery of natural resources with associated greater economic benefit with no or minimal adverse impact on adjacent correlative rights.
Yes.
Mr. Chairman, that concludes my examination of Mr. Atkins.
Thank you. Deb Vision, any questions for this witness?
No questions for this witness.
Board, any questions for this witness? Mr. Moon.
So I understand this is an illustration. But do you plan to do the boundary wells in the Lower Castle Peak and the Wasatch versus, why not the Uteland Butte where maybe that's the higher producing zone? Because you're going to get 9 versus 8. Just a question on that.
Yeah, I think all those are options. I think that's part of what went into the request for up to 6 wells on the boundary. Yes, sir. So I think all those are an option. Again, kind of on slide J, just depending on what creates the most net present value for everyone involved.
Thank you.
Any other questions?
Yeah, yes, could we go back to Exhibit I also? And I just want to know, is there a good attempt or a good faith attempt to make this to scale? Or is this more of an illustration? It's pretty close.
There's a good faith attempt. It's not exactly to scale. It is an illustration, but it is representative to an extent.
Okay, and so the wings of your fracs are slightly offset, and you've designed it that way? Is that what that illustrates?
Yes, sir.
Okay, thank you.
Any other questions? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would move for admission of Exhibits A through J and Exhibit Z as supplemented.
Exhibits A through J and Exhibit Z are so admitted.
Thank you. With that, I'd like to reserve some time after the division's presentation for a closing statement.
Of course. Division, over to you.
Yeah, the division's position can be gleaned from the filing that the division filed in this case. The division does not oppose it. It recognizes the comment letter from Stanley Holmes, and similar to what Mr. McDonald outlined, recognizes that air quality issues are handled by a different agency and are not relevant to the current discussion, and the division does not oppose this compulsory pooling.
All right, board, any questions for the division? Mr. McDonald?
Thank you, Mr. Chairman. I think it's fairly straightforward request. It's very consistent with what the board has ordered before. I think that UNTAH has clearly met its burden of proof that this is necessary to carry out the statutory duties of the board. And we thank you for your time and attention, and particularly to the board and the IT people to allow UNTAH's witnesses to appear virtually.
Noting that the comments made by Mr. Holmes are maybe outside the jurisdiction of the division and this board, if Mr. Holmes is here, I would like to give him an opportunity to come up and speak. I don't believe he is. All right. Thank you for that. I would entertain a motion. Oh, division, sorry.
Sorry, just a quick clarification. I had a mental error. This is obviously not compulsory pooling. The division does not oppose the relief as requested. Sorry for that. Please excuse the mental error on that.
Noted.
Even notice.
Thank you.
I would make a motion that we approve this request for agency action.
Any last comments from the board? Seeing none, all those in favor say aye.
Aye.
Aye. Let the record show that was unanimous. Mr. McDonald, could you please prepare the necessary documents?
Certainly. Thank you, Mr. Chairman.
Which brings us to item number 3, docket number 2023-15, cause number 470-09. This matter has been dismissed without prejudice, which brings us to item number 4, docket number 2023-16, cause number 130-18. This matter has been withdrawn without prejudice, which brings us to item number 5, docket number 2023-17, cause number 132-16, in the matter of the request for agency action of Excel Resources LLC on behalf of Excel Setco LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 100 or 1,280 acre or substantial equivalent drilling unit established for the production of oil and gas and associated hydrocarbons from the lower Green River Wasatch formations. I will now ask for appearance of counsel.
Thank you, Mr. Chairman. Mitch Mayo of Lear & Lear PLC on behalf of XCL Resources and XCL Asset Co. And just for the board's note, I'm texting with them, trying to get them situated. They are appearing remotely, so forgive us a minute here if we need.
Okay.
Trevor Guel with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Great. Over to you, Mr. Mayo, while we get things worked out.
Thank you, Mr. Chairman. I apologize for being on my phone. I'm, as I said, trying to coordinate with clients in Houston.
Hey, Mitch.
You heard that too, right?
Yes.
Okay. Is that you, Kevin?
The voice in your head.
Hey. All right.
Okay, is the volume okay? Is it too loud? Not loud enough?
I think it's okay.
Seems
Great.
like it could be a little louder. And
All right.
Kevin,
Is that better?
it sounds like it's a little muffled for the room. Maybe you guys could scoot a mic closer to you, or.
Got it right next to me. Let me make sure, just because the Google Meet's a little bit different. So let me see if I can. One second, I'm so sorry. There. Try connecting.
Is that any better?
yes.
It seems to be much better, yeah.
Okay, great. Sample it. Deal.
Mr. Chairman, members of the board, as I said, Mitch Mayo on behalf of XCL Resources and XCL Asset Co., the petitioners in this case. With me today on the screen are Mr. Kevin Ananson, Vice President of Business Development and Land, and Mr. Mark Gravy, Executive Vice President of Reservoir for XCL. I'd like to thank the board for their allowance of the witnesses testifying remotely today in this uncontested matter. Could we please have the witnesses sworn in at this time? Mark, Kevin?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, thank you. To begin, I'd like to start with the resumes of Mr. Ananson and Gravy, which have been submitted as Petitioner's Exhibit A. If called to testify, they would confirm them as true and correct. They both have appeared as witnesses before this board numerous times, most recently in January in 4 consolidated matters. Mr. Ananson will be acting as a fact witness again today. Mr. Gravy has been recognized in past causes as an expert in reservoir engineering and general operations, most recently in January, and with presumed stipulation from division, he'll be testifying as such again today.
Division, any concerns?
No objections.
Board? Seeing none, they're recognized as expert witnesses.
Thank you, Mr. Chairman. Also, as a reminder, in keeping with past practice, I'll be moving for admission of our exhibits at the end of our case in chief. This cause is a straightforward compulsory pooling matter. It involves a 2-section 1280 or substantial equivalent drilling unit comprised of sections 13 and 24, 2 south, 2 west in Uintah County. I may refer to those as the subject lands here today. The wells at issue produce from the lower Green River Wasatch formations. The drilling unit, covering sections 13 and 24, 2 south, 2 west, was established by the board in its order, entered on April 23rd, 2018, in cause number 139-153, and as amended by this board in cause number 130-06. Together, these current orders allow for up to 32 wells in any combination to be drilled and produced from the subject formations. A true and correct copy of both of these orders is submitted as Petitioner's Exhibit B and Exhibit C in this cause. Relevant to this hearing, XCL has drilled, under the current orders, the following 7 wells. The Shake 52-24-2413-22O, the Shake 61-2413-22R, Shake 73-2413-22Y, the Bake 54-2413-22G, the Bake 56-2413-22B, the Bake 67-2413-22V, and the last, 58-2413-22R. Each of these is a 2-mile horizontal well producing from sections 13 and 24. Collectively, I'll refer to these as the subject wells. When XCL filed its request initially, there were 4 working interest owners and 9 unleased mineral owners that were subject to the request, in addition to the named estates. The names of these parties appear on Exhibit 2 to the request for agency action, and I'll refer to them in this hearing as non-consenting owners. After the request was filed, XCL received correspondence. Is anyone else getting feedback from me? Is it just me? Okay. When XCL filed its request, after their request was filed, they received correspondence from and reached agreements with 3 of these owners. One working interest owner, American Atlas Resource Corporation, formerly known as WEPCO, reached out and sold its lease interest to XCL. And 2 mineral owners, unleased mineral owners, Jonathan Tanner and Miss Louisa Perkins, each reached out and executed leases with XCL. Accordingly, those 3 parties, XCL would like to withdraw from the request formally at this hearing today. In light of this withdrawal, the request for agency action here today involves the compulsory pooling of the following parties: Saba Energy of Texas, Inc., Twin Creek Altamont Basin Trust, Quiana 2B, Diane Sue Nishi, David Scott Russin, Daniela Tanner Graziani, Matthew Tanner, David Tanner, Stephanie Tanner, and May Tanner, formerly known as Angie Goodwin. In addition to these working and unleased mineral owners, unleased interest owners, XCL seeks to pool to the extent necessary the estates identified on page 3 of the request for agency action. Although XCL believes it has leased and located all of the heirs and devisees of said estates, out of an abundance of caution, we've included them here at this hearing today. The affidavit from the Uintah Basin Standard, which is the publication used to notify the unlocatable owners, is included as Petitioner's Exhibit J. This board granted publication by notice by order in this cause. Aside from WEPCO, Mr. Tanner, and Ms. Perkins, as just discussed, no owner has responded or paid their proportionate share of well costs as a result of these efforts. Accordingly, XCL will seek to pool the 10 remaining non-consenting owners and any individuals inheriting under those estates as of the date of first production. As I said, no interested parties have timely objected. Therefore, pursuant to Admin Code Rules R641-104-150 and R641-108-400, XCL would formally move to enter default against those parties. We would also note that the division on April 10th filed a response and notice of non-opposition in this cause. I'll let the division explain its position, but to paraphrase, essentially, as long as the regulatory requirements are met as deemed by the board, the division has no opposition to granting the pooling. As we will show today, XCL has met each of those requirements. XCL seeks to have the board apply the terms of a JOA that has been found to be reasonable and justified and customary in the basin by this board before, and to apply the acreage-weighted average landowner's royalty applicable to this unit. Each of those things, the JOA and acreage-weighted royalty, are demonstrated in Exhibits G and H, respectively. Notice was provided to all interest owners at last known addresses of record and by the aforementioned publication notice ordered by the board. Petitioner's Exhibit I on file in this cause contains photocopies of the certified mailing return receipts for the mailings in this matter. Finally, the board has jurisdiction over this cause pursuant to 40-6-6.5. The testimony and evidence presented will establish that the regulatory and statutory requirements deemed to, excuse me. The statutory and regulatory requirements to deem any unleased and uncommitted owners as non-consenting parties and to compulsory pool their respective interests as to the subject wells and the associated drilling units has been met. And with that, I'll begin with my examination of Mr. Annenson. Mr. Annenson, can you please state your full name and business record or business address for the record?
Sure, it's Kevin Annenson, Vice President of Business Development and Land. Our address is 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Thank you for that. And do you currently have supervisory role over the lands and the subject wells at issue today?
I do, yes, that's correct.
Okay. Do you, in that role, do you exercise a supervisory role over the land records associated with these units?
Yes, that's correct.
Can you please provide the corporate and bonding status for XCL?
Yeah, so XCL is a Texas corp in good standing, having its principal place of business located here in Houston, Texas. We're fully bonded with all.
Okay. All appropriate agencies, state, federal?
Yeah. Sorry, this is correct, sir.
I'd like to start your testimony by turning your attention to some of the exhibits that will help orient the board, and we'll go through these as quickly as we can.
Let me make your screen a little bit bigger.
How is that?
It's good. Give me 1 second. Okay, there we go. So, I'm sorry.
Can you guys see it okay?
Yes, sir. Yes.
Okay. Do you recognize Exhibit D?
I do.
And was this prepared by you or under your direction or supervision?
Yes.
Can you please quickly tell the board what this exhibit demonstrates? And this is a 2-page exhibit, so I'll show you both pages.
Sure. So this is the first one is the kind of regional location map that shows the DSU outlined in red. You can see the Uintah County line right there in green, and we are about 2.5 miles west of Roosevelt.
Okay.
Right in that area where Roosevelt is. Yep.
Thank you. Turning now to Exhibit E. This is also a 2-page exhibit. Do you recognize this exhibit?
I do, yes.
Okay, and before we start, I'd like to apologize to the board for the labeling confusion. This is labeled both Appendix L and Exhibit E. It is Exhibit E for this matter. It was an appendix to a prior business record of XCL's. Is that correct, Mr. Annenson?
Yes, that's correct.
Okay. And can you please tell the board how this was, how XCL came into possession of this, where this was created?
Sure. So this is this comes out of our DOTOs, which is our division order title opinions from our Utah licensed attorneys. And so it's a breakdown of all the mineral ownership tracts.
Okay. And how were these interests determined in particular?
I'm not sure I understand your question. Sorry.
Well, did you have a title opinion prepared relevant to this matter today?
I do, yes, that's correct.
Okay. And who prepared that? And do you have an effective date on that title opinion?
I do, yeah. So that was actually prepared by Lear & Lear. And this was a supplemental opinion done to a previous opinion, and it was dated effective as of November 28, 2022.
Okay, thank you for that.
Great.
Now, turning to exhibits F, G, and I, which we'll discuss collectively. Exhibit F is labeled authorization for expenditure. Exhibit G is the JOA. And Exhibit I. Do you recognize these three exhibits, Mr. Annenson?
I do.
Okay. And are these official business records of XCL prepared in your ordinary course of business?
Yes, that's correct.
And what are these exhibits, Exhibit F, the authorization for expenditure, JOA, and the well proposal letter here, what do these collectively demonstrate?
So these are part of the well proposal packets that we send to all of our working interest and UMI owners within each subject well. The Exhibit F, which is the AFE, it provides the owner a breakdown of the cost of the wells and the portions to their interest should they decide to participate in these wells. And then the next one, if you want to go to Exhibit G, I believe was the JOA.
That's right.
Yep. And so the JOA is for the wells, provides that so the JOA for the wells is a term that will govern their interest should they choose to participate. And then you should have an exhibit, or you'll have an exhibit B, I shouldn't say should, there's an exhibit B to the JOA that provides a sample oil and gas lease for their consideration.
Okay. And Exhibit I.
Okay, and then Exhibit I would be your well proposal letter. Sorry, I'm squinting because I'm looking across the room, which informs them of their options to lease or to participate in the wells should they choose.
Okay, so it's typical for XCL to send a well proposal letter with an AFE and a JOA as part of an election packet to unleased or non-committed interest owners.
Yep, that's correct.
In addition to these three documents, is there anything else that you typically send in these election packets and in the election packets you send to these owners today?
Yep. So we send a plat map that's depicting each proposed well and identifying where the wells will be drilled, and that includes the target formations and then the top and bottom hole locations and well tracks.
Okay, and this well proposal packet, this letter, AFE, JOA, and plat maps was sent to all working and unleased mineral interest owners in this unit. Is that correct?
That's correct.
What dates about were those sent?
So we mailed them in the spring of 2022, or all got mailed out. We sent the first round in January, towards the end of January of 2022. And then we received additional and alternative addresses through additional research. So we sent out another mailing March 1st and 2nd of 2022.
Okay. And now, thank you for that. Turning to Exhibit K, which was filed separately in this cause as it came in after the filing deadline for the exhibits. Do you recognize this exhibit, Mr. Annenson?
I do, yes.
And was it prepared by your office or by my office under your direction or supervision?
Yes, that's correct.
Please tell the board what this exhibit is and what it shows.
Sure, it's just a copy of the returns, proof of service for the copy of the request for the agency action that was sent to each interested party.
Okay. And did you then mail a copy of the request for agency action at issue today to each party identified to be pooled?
Yes, that's correct.
Okay. What about for parties who either didn't have a valid address of record or had no last address of record? How did you effectuate notice on those parties?
We sent it to the last known address of record.
Okay. And for parties who either don't have a last known address of record or who you know it's an unlocatable address of record, did you make any other efforts to notify them of this pending request for agency action?
Yes, we did.
Okay. And what efforts were those, or how did you accomplish that?
So pursuant to the order of the board in this case, what we did is we published notice of opportunity to lease or participate in all these oil and gas wells, and the notice of request for the agency action. This was published in the Uintah Basin Standard for 2 consecutive weeks.
Okay. And the intent behind doing that is both to notify the parties of the request for agency action and the hearing today, but also to notify them of their opportunity to lease or participate in the wells. Is that correct?
That is correct.
Okay. Turning quickly to Exhibit J, this also was filed separate from petitioner's exhibits in this cause. Exhibit J, affidavit of publication. Do you recognize this exhibit?
Yes.
And was this exhibit prepared by my office under your direction or supervision?
Yes, that's correct.
Okay. Can you please tell the board what this exhibit is?
It's a copy of the affidavit of production that's prepared by the Uintah Basin Standard, verifying that it was published notice of the offer to lease or participate in the oil and gas wells, and the supplemental request for agency action for those 2 consecutive weeks, which was March 22nd and March 29th of 2023.
Perfect. Yep, right there. Okay. Given the notice by mail and by publication of this hearing and the request, have you had any conversations with unleased mineral owners or uncommitted working interest owners that you'd like to update the board on?
Yeah, and as mentioned earlier, or that you mentioned earlier, after the request was filed, we received correspondence from some of the parties identified within the request, and ultimately we reached an agreement with these owners for the voluntary pooling of their interest. Do you want those owners, or?
Yeah, please identify them.
Sure. So one was Atlas, American Atlas Resource Corporation, or WEPCO.
Okay.
Which was a working interest owner, and they agreed to sell their working interest in the lease to XCL.
Okay.
And then XCL received an executed lease from 2 of the unleased owners, which was Mr. Jonathan Taylor and Miss Louisa Perkins.
Okay. And you said Mr. Jonathan Taylor, but I think did you mean Mr. Jonathan Tanner?
Tanner, sorry.
That's all right. Now, turning to Exhibit H, do you recognize this exhibit, Mr. Anderson?
I do. The brain numbing one for us.
Was this prepared by you or by XCL personnel under your direction or supervision?
Yes, it was.
Okay, and can you please tell the board what this is and what it shows?
Yeah, so this table is how we calculate the acreage, or the weighted average for landowner royalties for the units.
Okay. And the total unit, as we talked about and you mentioned, is 1,280 acres, but this calculation only uses approximately 969 acres. Can you explain to the board why that is?
Yeah, that's because the statute limits that the landowner royalty calculations for the fee mineral owners who were leased prior to the commencement of drilling of the well.
Okay. Now, as quickly as you can you walk the board through the calculation method just so they can follow if they'd like to?
Yeah, sure. So first we get we identify the net mineral acres covered by each lease. And then we identify that lease royalty applicable to each lease.
Okay.
And then after that, yeah, there you go. We then calculate the participation factor,
Okay.
which is the lease net acres divided by the total leased B net acres in the unit. And then finally, we multiply the participation factor determined by each lease by the lease royalty applicable to that lease to get that weighted royalty for each one.
Okay.
And in this case, the total came out to be 15.045032%.
Okay. Thank you very much. Finally, not finally. Yes, finally. I'd like to turn you to Exhibit G, the JOA, briefly, just to talk through this. Is this, what form are you using for JOAs in these subject wells?
The AAPL form, the 610-1989 model form operating agreement.
Okay, and is this the form standard practice in the basin for operators and for XCL?
Yes, that's correct.
In your opinion, are the terms in this JOA reasonable and customary in the basin?
Yes, that's correct.
Okay. Are there any modifications from the standard form that are relevant to this hearing? And if so, can you give us an example of one?
Yeah, sure. And so in this well, we've elected 100, 400 risk penalty, assessment risk penalty, excuse me. A 100% applicable to the surface equipment beyond the wellhead connection, and a 400% penalty applicable to the drilling cost.
Okay. In your opinion, are those modifications reasonable and customary?
Yes, that's correct.
Okay. And what risk assessment penalty is XCL seeking today in this hearing?
As opposed to the 100, 400, this one would be a 100, 300.
Okay, so you're asking if the board approves. I'm sorry, go ahead.
I cut you off, keep going.
No, if the board approves the request today, they'll be approving 100 and 300% non-consent penalties. Is that right?
That is correct.
Okay. Has XCL entered into, or would XCL enter into JOAs that contain these similar provisions as contained in Exhibit G here?
Yes.
Okay. Now, I'd like to go to Exhibit C to the JOA. Can you briefly tell the board what that is?
This is the form for the accounting procedures to apply in conjunction with operating subject wells. Yeah.
Okay. Sometimes they may have heard of it as the COPUS.
That's correct.
Okay. And this is reasonable, and the use of this form is reasonable and customary in the basin?
Yes, that's correct.
Okay. Now, I'd like to look at the third paragraph of that Exhibit C. Let me see if I can find it. It's titled Advancements and Payments by the Parties. Can you see that?
Okay. Yep, got it.
Okay. Can you tell the board what this is and how it's relevant today?
Yeah, so this provides for the assessment of interest on late payments for low cost.
Okay. And how is interest determined on those late payments?
The rate so the rate assessed for the late payments of well cost is based on the applicable prime rate published by the Wall Street Journal plus 3% per annum. And then if the Wall Street Journal ceases publishing interest rates, then it's based on the prime rate published by the Federal Reserve plus 3% annum.
Okay. And now finally on the JOA, Section 3 of the COPUS titled Overhead. Can you tell the board what this clause provides and why we're discussing it today?
Sure. So it deals with the overhead costs or the overhead expenses and applicable fixed rates.
Okay. So essentially this section is well costs that an owner who is pooled into this well and has this JOA applied. This describes how those well costs will be treated.
That's correct.
Okay. In your assessment, Mr. Ananson, are the terms and conditions of the JOA, specifically including those terms we discussed in Exhibit C to the JOA, reasonable and customary in the basin?
Yes, that's correct.
Okay. With that, I'm done with my examination and ready to move on to next witness.
Division.
No witnesses or no questions for this witness.
All right, board, any questions for this witness?
Okay.
Oh, Mr. Moon.
So the average weighted royalty is quite low in this drilling unit. It appears that Section 13 has a well that was producing up till a few months ago, and I assume prior to that, other wells that were held. My question is, are you completely comfortable that those old 12.5% leases were effectively held over all the years that they've been held?
Is that a question for
I am,
me
yes.
or witness? Okay.
I answered your question. For me, Mitch, sorry.
Yeah,
Yes,
for
yeah.
you, Kevin. Did you hear the question?
I am, Mr. Moon, yes, sir.
That-
Yep.
Okay. Thank you for that. With that, as I said,
Just
I'm done.
Any other questions before we, back to you.
Sorry, thank you.
Dave.
No, you're good.
Sorry.
With that, as I said, I'm done with Mr. Anderson. He'll still be available if additional questions come up. I'd now like to move on to Mr. Gravy. Will you please raise your hand and then state your name and business address for the record as well?
Sure. Mark Gravy, Executive Vice President of Reservoir and Development. Same address, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. And as Executive Vice President of Reservoir and Development, can you please tell the board your job responsibilities generally and as they relate to this unit?
Absolutely. My team and I are responsible for designing the development of the asset. So how many drilling rigs, timing, and how many wells to develop in each sub-formation.
Okay. I'd like to remind the board and council that Mr. Gravy is testifying as an expert witness today in those subjects. Turning your attention to Exhibit F, the AFE. This has already been authenticated by Mr. Ananson. Can you please testify, as Mr. Ananson testified, these AFEs detail the estimated drilling costs for each of the subject wells. Can you please quickly just tell the board what the estimated cost for each of these subject wells is?
Sure. For the Shake 52, 2513 to 20, approximately 7.55 million. For the Shake 61, 2413, 22R, 7.65 million. The Shake 73, 2413, 22Y, 7.43 million. The Bake 54, 2413, 22G, 8.05 million. The Bake 56, 2413, 22B, 7.56 million. The Bake 67, 2413, 22B, 7.58 million. For the last 58, 2413, 22R, 7.56 million.
Okay, so all of them are around $7.5 to $8 million in well costs for the drilling and completion.
That's correct.
Collectively, Mr. Gravy, what was the non-consenting owner's proportional share of these estimated costs to drill and complete the subject wells?
3.21%, approximately.
So they own approximately 3.21% of the interest in the subject wells. If I add up the estimated costs of each of the 7 wells, I get almost $54 million in total costs for those 7 wells. Can you tell the board what percent or what the dollar cost for these non-committed parties was, what their dollar cost in drilling costs for these 7 wells?
$1.7 million.
Okay. And has XCL paid those costs on behalf of the non-consenting working interest owners?
Yes.
Okay. In your expert opinion, Mr. Gravy, were these costs fair, reasonable, and necessarily incurred?
Yes, they were.
Okay. XCL doesn't include P&A costs in their AFEs, is that right?
That is correct. We do not include P&A costs because the timing of that expense is too long dated. It is approximately $100,000 per well.
Okay. Now, finally, can we talk about the risks involved in drilling and or completing these wells? XCL came in recently in January and talked about batch drilling some wells and about the risks involved. This is another batch or cube development of 7 wells. Can you please talk to the board a little bit about the financial, logistical, et cetera, risks that XCL faces when drilling, developing a unit like this?
Sure. One of the primary risks is the about a year-long capital investment cycle prior to first production. Commodity markets are volatile, so we are exposed to whatever may happen during that time. In combination, the wellbores themselves face geologic and operational risk that could put wellbores in jeopardy. These specific wells targeted to produce from 5 different subformations. Each one comes with its own risk. Some of them have never been delineated on this portion of our acreage before. So we invested in these wells knowing that these risks exist because we believe it is the most prudent way to operate the acreage.
Okay. And so in your opinion, does the financial, technical, and operational risk that XCL incurred in drilling these wells justify the risk compensation award requested today?
Yes.
Okay. With that, I'm done with my direct examination, and we'll open him up to questions.
Division.
Yeah, just one quick question. I believe this was mentioned earlier and that we saw it in our review of your exhibits, but the packet that gets sent out to uncommitted interest owners, it contains not only the estimated cost, but also their estimated share or ownership in the area, so they could calculate their estimated cost. Is that correct?
That's correct.
Perfect. Thank you. That's the only question that the division had.
Board, any questions?
Sorry.
Seeing none, back to you, Mr. Mayo.
With that, and given in the limited number of questions, XCL has met all the statutory and regulatory requirements to pool the parties here today. Each received notice both of the original drilling and of the request for agency action that's at issue. The sufficiency of that notice is demonstrated by the fact that 3 parties reached out and were able to successfully negotiate participation in these wells as a result of that. And the silence from the remaining owners is further evidence. At this point in time, given the lack of response and the clear demonstration of meeting the regulatory and statutory goals, I would simply ask for the board's approval of the request for agency action as amended today to remove those 3 parties who have committed since the filing. And with that, I'd rest. Oh, I probably should move for admission of my exhibits as well. I'm trying to, I think it's exhibits A through K in this matter.
That is correct.
Thank you. I'd like to move for admission of exhibits A through K.
Exhibits A through K are so admitted. And now it's over to the division, I believe.
Perfect. Thank you, Chairman Borden. Yeah, the division filed a notice of non-opposition pending the evidence that would be produced today. After the division's review of the exhibits beforehand, as well as observing the evidence put on show today, the division is satisfied that the burdens have been met and is supportive of granting this request for compulsory pooling. I got it right this time. I was just so excited about compulsory pooling. I jumped the gun last matter. And just wants to note, last month's hearing, there was an in-depth discussion on what's fair concerning a notice of opportunity to participate. The board indicated a strong preference for giving these mineral interest owners at least an estimate of their percentage of ownership so that they could calculate their cost. And the division was very pleased in its review of the exhibits that was being included, consistent with the board's preference. With that, the division is happy to work with counsel for XCL petitioner to make sure that the order reflects the changes for those individuals who are able to get lease. So the changes from the original request, and overall is supportive again. Thank you.
Mr. Mayo, any comments or response to the division's discussion?
I believe this request has been proven and should be approved, and with that, I'd submit.
Okay. Board, any questions for the division? Seeing none, I could entertain a motion, or we could adjourn to discuss this.
I'll make a motion to approve the request for agency action with the amendment of, or the stipulation that remove those three parties that are excluded.
I second it.
Any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Mr. Mayo, could you prepare the necessary documents?
I'm happy to do so. Thank you for your time.
Thank you. I believe we have time to go on to the next item here before lunch. Does anyone need a bio break or anything? No? Okay. Stay dehydrated. Which brings us to item number 6, docket number 2023-018, cause number 130-19, in the matter of the request for agency action of Uintah USA, Inc., for an order extending the board's orders in cause number 139-150 and 600-03 to establish a special stand-up drilling unit for the production of oil and gas and associated hydrocarbons from the lower Green River Wasatch formations. I'll now ask for appearance of counsel.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner Uintah USA, Inc.
Trevor Gruel with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Over to you, Mr. McDonald.
I just want to make sure our remote witnesses are available. If that could come up on the screen, I'd appreciate it. Thank you. Mr. Chairman, members of the board, appearing virtually from the Woodlands, Texas, today on behalf of Uintah USA are Mr. Jordan Lear, the senior land negotiator, Mr. Josh Reamer, who's geoscience manager of development, and Mr. Kendall Brown, the manager of the Uintah Reservoir Engineering. I would ask that they be sworn in at this time.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I do.
Mr. Chairman and members of the board, the resumes of all three witnesses were submitted collectively as Exhibit A in this cause. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Lear will be a fact witness only. Messrs. Reamer and Brown have previously been recognized by the board on several occasions as experts in geology and reservoir engineering, respectively. Based on their resumes and the previous recognition, and presuming the division has no objection, we again request that they be recognized as experts in those fields for purposes of this cause.
Division, any concerns?
No objections.
Board, any concerns or comments? Seeing none, they are so recognized.
Thank you, Mr. Chairman. Again, I will be moving for admission of our exhibits at the end of our presentation in chief. Members of the board, today Uintah is before you seeking establishment of a special drilling unit, stand-up drilling unit for lower Green River Wasatch production, comprised of sections 14, 23, 25, and partial section 35 of Township 4 South, Range 3 West in Duchesne County, through extension of the 139-150 and 600-03 orders to those lands. Like the 139-150 order, Uintah does not seek overlapping drilling units for vertical short lateral and long lateral wells. Instead, Uintah requests production from any existing vertical, directionally drilled, and short lateral wells remain on a wellbore basis until the first long lateral well is drilled, and then effective as of the first of the month following the date of first production of that long lateral well, providing for production from all of the wells to be allocated on the requested drilling unit basis. As the board is aware, this is commonly referred to as conversion. This will prevent premature and unnecessary modification of existing rights to production until such time that the drilling of the first long lateral well occurs and mandates such a modification. As has been done in previous Ovintiv spacing causes, including the 139-150 cause, Ovintiv requests that the board take administrative notice of the testimony of Mr. Mike Jensen and the exhibits admitted into evidence in the 139-134 hearing pertaining to the concept of drilling unit conversion and how correlative rights in existing wells remain protection thereby pursuant to Utah Code annotated section 63G-4-206, subparagraph 1B, Romanet 4. I don't know if the board wants to do that or would wait until the end.
So noted.
Thank you. Also similar to the 139-150 order, Ovintiv is requesting authorization to drill up to 40 long lateral horizontal wells and up to 8 vertical, directional, or short lateral horizontal wells per drilling unit, or to the extent 8 or more such wells already exist, to permit such further new wells to be drilled without prior board authorization. This ensures maximum recovery of resource from the drilling unit. The 603 order modified the 139-150 order to reduce the north-south or the heel-toe setbacks to 100 feet. The requested extension of these two orders is similar to the relief granted by the board in the 130-14 order entered this past January, which included the establishment of a similar special adjacent drilling unit comprised of sections 13, 24, 25, and partial section 26 in the same township and range. True and correct copies of the 139-150, 603, and 130-14 orders were collectively submitted as Exhibit B. However, like the 130-14 order, there are some unique circumstances surrounding the requested drilling unit requiring some deviations from the 139-150 and 603 orders. Specifically, Ovintiv will be testing up to a 2.5-mile lateral. In addition, because of the Uintah Special Meridian Boundary, Section 35 is a partial government section only, and the adjacent lands to the south are within the Greater Monument Butte Super Unit. Without inclusion of that partial section in this drilling unit, it's probable that it would not be independently developed. Finally, because the meridian line is diagonal, Ovintiv is requesting a 200-foot southern toe setback to ensure that the Greater Monument Butte unit lands are not impacted by wells drilled on the requested drilling unit. Since Indian mineral lands are involved in the requested drilling unit, a communization is required, and the agencies, whether under federal guidelines or by practice, require a spacing order of the board for such a communization agreement to be approved. This is another reason why Ovintiv is seeking the drilling unit before you today. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3B, and 40-6. Notice was sent via regular mail to all production interest owners within the requested drilling unit, to the working interest owners, including unleased owners, in the established drilling units, or if unspaced, the quarter-quarter sections adjacent to the affected areas due to the setbacks, and to the Bureau of Indian Affairs and the Bureau of Land Management, being the governmental agencies having oil and gas jurisdiction over portions of the land. The mailings were sent to these parties at their last addresses disclosed by the relevant BIA, BLM, and Duchesne County records. The record will also reflect that notice was duly published in the Salt Lake Tribune on April 2nd, 2023, in the Uintah Basin Standard on April 5th, 2023, and in the Deseret News on April 7th, 2023. The division filed a response on April 19th, 2023, expressing non-opposition, presuming Ovintiv meets its necessary burden of proof by providing sufficient evidence at hearing justifying the drilling of more than one well in the drilling unit without committing waste. As today's testimony will reflect, these conditions will be met. No other objections or responses were received. And with that, I'll commence my examination of Mr. Lair. Mr. Lair, would you please state your name and business address for the record?
Sure. My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with Ovintiv?
My current position is senior land negotiator with responsibilities over the area at issue, among others.
For the record, would you please state Ovintiv's corporate and bonding status?
Sure. Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and merger of Oventive Production Incorporated.
I'm going to show you what have been marked as Exhibits C through H for purposes of this hearing, shown on the PowerPoint, and I presume you also have copies in front of you. Do you recognize these exhibits?
I do.
Were they prepared by you or Oventive personnel with your review and input?
Yes, they were.
Turning your attention to Exhibit C, would you please explain what this shows?
Sure, this is just the regional locator plat showing the DSU at issue in red. It's located approximately halfway between Duchesne City and the town site of Mighton.
Turning your attention now to Exhibit D, would you please explain what this shows?
Sure, this is a plat of the requested DSU, again outlined in red, and the existing producing wells. All oil and gas is tribally owned within the DSU except for the northwest quarter of the northeast quarter and the northeast quarter of the northwest quarter of Section 14. Of note, Section 35 is currently unleased tribal minerals, but Oventive is currently engaged in negotiations with the Ute tribe and UDC to lease the tract, or will enter into a JOA with their designated lessee. Oventive will not drill into Section 35 unless and until it is leased, and if applicable, a JOA is in place. Within Section 14, there's one producing vertical well, being the Ute Tribal 91443. Within Section 23, there are two vertical wells that are producing of the four shown. Two producing wells are the Ute Tribal 82343 and the Ute Tribal 92343. The other two shown have been temporarily abandoned. They are the Ute Tribal 52343 and the Ute Tribal 72343. Moving to Section 26, there are four vertical wells shown. Ute Tribal 62643, the Ute Tribal 82643, the Ute Tribal 92643, and finally the Ute Tribal 152643. And there are currently no producing wells in Section 35. Additional shut-in wells have been identified on pages 4 through 6 of the request for agency action. All wells were drilled on tribal minerals under the general well siting, and production has been allocated on a wellbore basis to date. There are no non-consents and no existing compulsory pooling orders, and therefore no recoupment owed. And in Oventive and my personal experience, when Indian minerals are involved, a spacing order not only facilitates, but is required for BLM and or BIA approval of a conforming communitization agreement, whether by guidelines or actual agency practice.
Now turning your attention to what has been marked as Exhibit E, would you please explain what this shows?
Sure, this is the BLM master title plat for the requested DSU. So it's showing Section 14, 23, 26, and 35 of Township 4 South, Range 3 West. And shows the lots and quarter section comprising the partial section 35 and the diagonal meridian line.
Now turning your attention to Exhibit F, would you please explain what this shows and its significance?
Sure. Exhibit F is the estimated gross working interest within the DSU. Its purpose is really to evidence that Oventive is the majority working interest owner with an estimated 85.36% working interest in the requested DSU. Of the unowned interest, approximately 11.03 is from the unleased tribal acreage in Section 35, and the remaining 3.61% is third-party leased and unleased fee acreage.
Now turning your attention to Exhibit G, would you please explain what this shows and in particular the significance of this hearing?
Sure. Exhibit G is just showing the existing horizontal well spacing around the requested DSU, which is again in red. And there's currently no applicable spacing order for the same. In pink are the lands subject to the 139-150 order. In gold are the lands subject to the 600-03 order. In teal are the lands subject to the 130-14 order. Purple and black are the lands subject to the 130-09 and 130-10 orders, which, like the 130-14 order, extended the 139-150 and 600-03 orders to apply to those lands. For all of these orders, they provide for conversion, the timing of which is for existing and short lateral wells, but not long lateral wells. It's effective the first day of the month following the date of first production from the first long lateral drill, and is effective as to the date of first production for the long lateral well. However, as to the DSU that we're proposing, the requested reduced setbacks for horizontal wells are to be effective immediately.
Now turning your attention to Exhibit H, would you please explain what this shows?
Sure, this is an illustration of how notice was provided within the red hatched area, again being the DSU requested. All production interest owners were notified, and then within the lighter pink area, all working interest owners, including unleased owners in the established drilling units and adjacent unspaced quarter sections, were notified.
All right. Directing your attention, I presume you have a copy of the original and supplemental certificates of mailing in front of you. Those were pleadings prepared by my office for this matter. Do you recognize the names and addresses that are shown on that?
I do. The names of all parties just mentioned with respect to Exhibit H are shown on there, as well as the governmental agencies having mineral jurisdiction.
How were those parties identified in their addresses?
The parties and addresses were compiled from Oventa's internal land records, including title opinions and a search of the BIA and Uintah County records prior to filing the request by our contracted land service company, Lone Wolf Energy Incorporated.
Right, for members of the board, again, the mailings were sent out regular mail because of the number of parties that were involved. So there is no Exhibit Z reflecting the certified receipts on this one, just for that clarification. With that, Mr. Chairman, that concludes my examination of Mr. Lair.
Division, any questions for this witness?
No questions for this witness.
Board, any questions? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Reamer. Mr. Reamer, would you please state your name and business address for the record?
Sure. My name is Josh Reamer. Business address is 4 Waterway Square, Suite 100, The Woodlands, Texas, 77380.
What is your current position?
Go ahead.
Go ahead.
Current position is the Geoscience Manager of Development with responsibility over the lands at issue today.
All right, I'm now going to show you what have been marked as Exhibits I, J, and K for purposes of this, as well as Exhibit L. I'm assuming you also have copies in front of you. Were these exhibits prepared by you or Uintah personnel under your supervision?
Yes, they were.
Okay, thank you. Turning your attention to Exhibit I, would you please explain to the board what this shows?
Exhibit I is the field type log, the Shell Brotherson 1-11B4 well. This well shows the stratigraphic definition for the Lower Green River Wasatch Transitional Formation, which comes from the 139-150, as well as shown in the 139-134 order. This exhibit also reflects the primary intervals which will be targeted in the requested DSU.
Turning your attention to Exhibit J, would you also explain what this shows and its significance?
Sure. Exhibit J is a log of the JMD 12443 well, which is near the area at issue today. This shows the correlative log of the primarily targeted intervals for long lateral wells from a well nearby the area at issue today. It also highlights the 5 primary targets in this area.
Now turning your attention to Exhibit K, please explain what this represents and its significance.
Sure. Exhibit K is a west to east cross-section through the area of interest. It shows and reflects the uniformity throughout the area. It also highlights that the Lower Green River Wasatch Transitional Formation constitute one common source of supply in the area, and it's consistent with the board's designation of those formations as one pool throughout the Uintah Basin.
Now turning your attention to Exhibit L, would you please explain what this shows and its significance?
Exhibit L is a map of the interpreted maximum stress direction by the DSU shown here. In blue, you have rows diagrams, which reflects wells with observed stress indicators, which come from FMI logs in the basin. The DSU is highlighted in red and shows an average fracture orientation of north 78 degrees west. This supports a stand-up north-south drilling-oriented unit.
Is it your expert opinion then that the uniformity and thickness make the Lower Green River Wasatch an attractive target for longer lateral horizontal drilling in this area?
It is.
Is it also your expert opinion that the fracture orientation supports a stand-up drilling unit orientation?
Yes, it does.
Finally, is it your expert opinion that the Lower Green River Wasatch constitutes one common source of supply in this area?
Yes, it is.
Mr. Chairman, that concludes my examination of Mr. Reamer.
Division, any questions?
No questions for this witness.
Board, any questions? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Brown. Mr. Brown, would you please state your name and business address for the record?
My name is Kendall Brown, and the business address is 4 Waterway Square, Suite 100, The Woodlands, Texas, 77380.
What is your current position with Ovintiv?
I am the reservoir engineering manager with responsibilities over our Uintah Basin position.
Mr. Brown, I'm going to show you what have been marked as Exhibits M through P for purposes of this cause. I assume you have copies of them in front of you as well. Were these prepared by you or Ovintiv personnel with your review and input?
They were.
Turning your attention to Exhibit M, would you please explain what this shows and its significance to today's request?
Exhibit M shows the location of the wellbore with respect to the unit boundaries as proposed. What Ovintiv is requesting for the agency action is to have 100-foot setbacks on the northern boundary of the unit and 200-foot setbacks on the southern boundary of the unit. The reason for the discrepancy here is related to the angle at which the southern section is adjacent to the Greater Monument Butte unit in order to both minimize waste as well as protect the correlative rights of the Greater Monument Butte unit.
Now turning your attention to Exhibit M, would you please explain what this shows and its significance?
Exhibit N is a description of estimated drainage radiuses around the fracture half lengths. Described in the table are the reservoir properties that were utilized to determine these calculations. The most relevant number for the board to take a look at in UDOGM is on the column labeled B, which is essentially the perpendicular drainage to the fracture. And what is shown here is at a 10-year time frame, we're looking at about 100 foot of drainage here, which is within the minimal to any drainage across the section lines. To note also on some of the reservoir properties described in here, Ovintiv does have PVT data collected on the Knoll well that is a couple miles just to the east of this particular unit. That's the Knoll 7H well. And that's what's being utilized to inform the reservoir fluid properties for these calculations.
Now turning your attention to Exhibit O, please explain what this shows and its significance.
So Exhibit O is a volumetric look at the number of wells proposed in the request for agency action. Through each line item, you can see the oil in place as calculated by the reservoir properties, as well as estimates for what the ultimate recovery of that would be, or there are 8 wells drilled into each formation. This gets you a total recovery factor of about a little over 8%, which is reasonable within the expectations of this type of oil and gas reservoir. The other thing just to note here is this is a 2156 acre unit. So that is inclusive of the sliver section there that's adjacent to the GMBU boundary.
Turning your attention to Exhibit P, please explain what this shows and its significance.
Exhibit P is a demonstration of why it's important to minimize waste while also protecting correlative rights. What's described here is what that increase in lateral length translates to for both the working interest owners, the royalty owners, as well as the state severance tax that the state of Utah would receive. So with the setbacks here, we would gain an additional 360 feet of lateral length, which is about a 2% increase in the lateral length. However, this does not result in a 2% increase in cost, as drilling the vertical and surface costs are fixed regardless of the lateral length. Ultimately, this translates to an increase to the royalty owners, to the working interest owners, and to the state severance to the tune of about 2% increase in revenue for all parties associated with the project.
Okay, so is it your expert opinion then that the proposed drilling unit, the amount of wells will maximize recovery both economically and in resource recovery without waste and with the protection of correlative rights?
It is.
Mr. Chairman, that concludes my examination. Mr. Brown?
Division, any questions for this witness?
No questions for this witness.
Board, any questions? Mr. Moon? Huh?
So to effectively drill the east side of this, or the west side rather, of this drilling unit, it would be almost a 4-mile horizontal. Is that correct? And you're planning to do so?
Good question. So drilling the east side of the unit would be about a 3-mile lateral, which would be the longest lateral in the basin, which we do feel is technically feasible. It is what we do in other areas that Uintah operates in. As it pertains to the western side of the unit, does become quite long. Pending results of drilling 3-mile wells may necessitate the need to instead utilize the short lateral horizontals in conjunction with the long lateral horizontal that's requested in this agency action to drill those western slots.
Okay, thank you.
Any other questions? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation. And Chief, at this time, I would move for admissions of Exhibits A through P inclusive.
Exhibits A through P are admitted as evidence.
No objections from the division.
Oh, sorry, Division.
You're fine. No objections from the division.
With that, Mr. Chairman, I'll reserve conclusory remarks after the division's made its statement.
Division, over to you.
Yeah, as noted in the division's response and notice of non-opposition, the division is not opposed to granting the relief requested here. After careful review of the exhibits, the division believes that the reduced setbacks are appropriate in this instance, especially after the testimony heard today.
Board, any questions for the division? Seeing none, I guess it's back to you, Mr. McDonald.
Thank you, Mr. Chairman. Again, this is a very similar request that the board heard in January. This is the adjacent lands, the special circumstances of this area with the special meridian line and the partial section are the only unique circumstances around it. But again, with the testimony and the exhibits that have been admitted into evidence, we feel that Uintah has met its burden of proof, and that we ask that the board grant the request as submitted.
Do we need to deliberate, or I would entertain a motion?
So I'd make a motion that we approve this request. I'd have a question for Fred and maybe Jordan. Any history on that meridian line, why it's that dome shape? Just curious. If anybody knows.
I think it's the history of it again. The original reservation was created back in 1860. and I think it followed topography and general belief of what the Indians were utilizing at as the lands in that area. That's the best I can guess, though. But other than that, I don't have any particular reason why it's surveyed that way.
Okay. Jordan, you're quite a bit younger. I doubt you have a lot more to add. But add to that.
I wasn't around when they did this, but yes, my understanding is exactly what Mr. McDonald had just referenced there. And obviously now it's the boundary between two different surveys, being the Salt Lake Meridian and the Uintah Meridian. So yeah, I think the history is as Fred had stated.
Okay, thank you.
So we have a motion. Do we have a second? Any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Mr. McDonald, could you prepare the necessary documents?
Certainly. Thank you, Mr. Chairman.
And that concludes item number 6. Do we know if lunch is available for us?
I saw it go past the door.
You did?
I did.
Okay.
I witnessed it.
I think we'll adjourn for lunch, and I hope it's okay to come back at a not the top of the hour, but in 1 hour at 12:40 and re-adjourn. We are off the record. Welcome back to the April 26th meeting of the Utah Board of Oil, Gas, and Mining. We are on the record, and we have our last item today, which is docket number 2023-019, cause number 475-07, in the matter of the request for agency action of KGH Operating Company for an order authorizing the drilling of the proposed Bonanza 36-2 horizontal well to be located in the west half of Section 36, Township 9 South, Range 25 East. And before we proceed, a couple of housekeeping items. First, over to you, Ms. Garrison. I believe you wanted to say something.
Yeah, I just wanted to mention that during my time as Assistant Director for the School and Institutional Trust Lands, I negotiated the KGH contract with them and issued the leases, some of which are involved in this hearing today, to see if anyone has any objections to my participating.
No objection on our part.
Thank you.
The division does not object and is also would like to kind of make a disclosure as well. Mr. Peterson, acting as an expert witness today, did consulting in the past for KGH and the division. No?
No, I said my brother is on the SITLA board.
I know, I'm kidding.
Oh, I didn't ever consult for KGH. No.
Oh, I thought you had. No. Okay. Scratch that. But his brother sits on the SITLA board. So if there are any issues, otherwise we'll plan on continuing to use Mr. Ellis as an expert witness in this case.
So do you like your brother?
Very much so.
All right. Two other.
Yeah, no objection to Mr.
Oh,
Peterson's.
thank you. Thank you. Two other items. The order granting leave to file a reply memorandum has been signed. And there is another order granting William Penn University's motion for allowance of electronic participation by witness. That was declined, and I don't know if you want to. No? Okay. In that case, I'll call for appearance of counsel.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner KGH Operating Company.
Trevor Gruelle with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining. One more housekeeping item is that last night William Penn made a filing, and I don't know if that needs to be acted on before we get into the substance of this.
Mike Bigley, counsel for the board. What was the nature of the filing?
It was a withdrawal of their objection.
So it was just a withdrawal?
Yes.
So you're just pointing it out. There's no board action required?
Okay. Let's proceed. That withdrawal is noted. To you, Mr. McDonald.
Thank you, Mr. Chairman. With me today are Mr. Tom Hauptman, the president of KGA Operating Company and TK Production Company, Mr. Jeff Wingeter, who is the geologist with Hone Engineering PLLC, which is a consultant for KGH, and Mr. Tom Hone, who's the member manager of Home Engineering PLLC, who's a consultant for KGH, and they'll be testifying today, and I ask that they be sworn in at this time.
Oh, thank you. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
The resumes of all three witnesses were collectively submitted as Exhibit A. If asked, each will confirm the information reflected in their respective resumes is true and correct. Mr. Hauptman will be a fact witness only. Mr. Home was previously recognized by the board as an expert in petroleum engineering and cause number 190-14 in 2015. If there are no objections from the division, we ask that he again be recognized as an expert in that field for purposes of this cause.
Division?
No objections.
Thank
Board? So recognized.
Thank you. This will be Mr. Wingeter's first time testifying before the board, so we will qualify him to be recognized as an expert in geology at the commencement of his testimony. I'd like to confirm that the board received the supplement to Exhibit Z, which was filed on Monday. It's just simply the additional green cards receipts of the certified mailings.
Yes.
All right, thank you. And again, I will be moving for admission of our exhibits at the end of the presentation in chief.
Perfect.
Members of the board, KGH today seeks board approval to drill the proposed Bonanza 36-2 well as a mile-long horizontal in the west half of Section 36, Township 9 South, Range 25 East in Uintah County. Under existing regulations, KGH must directly seek board approval due to some unusual circumstances with the well. True and correct copies of Utah Administrative Code Rules R649-3-2 and R649-3-3, which are the applicable regulations, were collectively submitted as Exhibit B. Now, dealing with those unusual circumstances, first, Section 36 is a partial section abutting the Colorado state line, comprised of what would otherwise be the west half of a full governmental section. KGH previously drilled the Bonanza 36-1 well as a less than 1/2 mile horizontal well in lots 3 and 4 of Section 36, which would be the equivalent of the east half southwest quarter. And it was drilled entirely upon a state lease and entirely within the boundaries of the Bonanza State Exploratory Unit, both of which are administered by the Utah School and Institutional Trust Lands Administration. Both of the conditions of approval, both the conditions of approval of the APD for the 36-1 well, and more importantly, our 649-3-2 subparagraph 10, require the filing of a request for agency action with the board to obtain board approval of any additional horizontal wells in a section. Second unique issue. The lateral of the proposed well will cross boundary between the west half southwest quarter and the west half northwest quarter of Section 36, which also constitutes an oil and gas tract ownership boundary and the boundary of the Bonanza unit. Under R649-3-2 subparagraphs 3 and 9, that may only be allowed if an exception location is granted. In addition, although there's common ownership in the south half southwest of adjacent Section 25 and the north half southwest of Section 36, KGH has proposed a terminus 50 feet south of the section line between those two sections, which additionally requires an exception location approval. However, under Rule R649-3-3, subparagraph 1.2, the division only has administrative authority to grant an exception location if, among other requirements, the written consent of the owners within a 460-foot radius along all points of the wellbore is obtained. As of last evening, with the withdrawal of William Penn and the granting of a lease to TK Production Company, KGH now has the written consent of all such owners except for Earlham College, which remains unleased. If the regulatory criteria for the division to administratively approve an exception location cannot be met, then the only option is to seek an exception location approval directly with the board through the filing of a request for agency action. The board always has ultimate jurisdiction over well locations pursuant to Utah Code Annotated Section 40-6-5, subparagraph 3B. As clearly spelled out in the request for agency action, KGH is committed to seek spacing for the 36-2 well if the exception location is approved once the well is drilled and sufficient technical data obtained to determine the appropriate drilling unit size. That will be required for proper pooling, whether voluntary or compulsory, and production allocation. In fact, that should be a condition of the order if the board grants the request for agency action. Furthermore, even if the exception location is granted, KGH is required to provide the requisite notice of opportunity to participate to Earlham College, thereby further protecting the rights of that owner. The testimony and evidence submitted today will confirm authorization to drill the 36-2 well as proposed, will promote exploration and development of oil and gas without waste and the protection of correlative rights, which is the board's statutory charge. For the record, I reiterate that the board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-5, subparagraph 3B, and Utah Administrative Code Rules R649-3-2 and R649-3-3. Notice was sent via certified mail return receipt to all owners, as that term is defined by statute and regulation, along with the lessors within Section 36 and adjacent Section 25. These mailings were sent to the parties at their last addresses of record disclosed by the relevant state and federal agency records. the realty records of the Uintah County Recorder, and the internal land records of TK Production Company and KGH. The record will also reflect that notice was duly published in the Salt Lake Tribune on April 2nd, 2023, the Uintah Basin Standard on April 5th, 2023, the Deseret News on April 7th, 2023, and the Vernal Express on April 10th, 2023. On April 5th, 2023, the School and Institutional Trust Lands Administration filed a letter in support of granting KGA's request. On April 10th, 2023, the division filed a response objecting to KGH request for agency action. In my opinion, and Mr. Gruelle can address this as well, the division raised 3 points. KGH must first seek the exception location approval from the division before seeking board approval. Second, the request for agency action is substantially administratively flawed because KGH has not obtained the written consent of all owners as required under R 649-3-3, and that KGH must first seek spacing. Last night, William Penn University also filed an objection, but last night it withdrew that objection because it had reached an agreement for leasing with KGH, or with TK Production Company, for whom KGH operates. KGH filed a rebuttal to the legal objections in a reply memorandum filed on April 19th, 2023. If the board deems it necessary, I'm fully prepared to provide further oral argument on those rebuttal points later in the hearing. Other than that, there were no other objections or responses were received by the other parties, including Earlham College. With that, I'll commence my examination of Mr. Hauptman. Mr. Hauptman, would you please state your name and business address for the record?
Tom Hauptman, P.O. Box 2235, Billings, Montana 59103.
And what is your current position?
I am the president of KGH Operating Company and TK Production Company.
Would you please, for the record, state the corporate and bonding status of KGH?
KGH is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state agencies. It is the duly designated operator on behalf of TK and others.
All right, I'm going to show you what have been marked as exhibits C through H, if you see them on the screen in front of you. Do you recognize these, excuse me, right there. Do you recognize these exhibits?
Yes.
All right, were they prepared by you or KGA personnel or consultants with your review and input?
Yes.
All right, on Exhibit H, which is not on the PowerPoint, I'll show you it here, right here. Is this an official business record of KGH?
Yes.
All right, thank you. All right, turning your attention now to Exhibit C, and I'm going to clarify something for the board. On some of the PowerPoints, you may see a different label on it. However, the material that's shown on it is exactly as the exhibits were filed with you. So on Exhibit C, would you please explain to the board what this shows?
This is a regional locator map showing the location of the proposed well and the access route right on the, it's on the state line, but the access route actually is through Colorado, through, you have to go around the Horn to go through to the town of Rangeley and then come back to that direction and go enter Utah from Colorado.
So approximately how much, what's the distance between Rangeley, Colorado and where the well site is?
It's like 12 and a half miles, I believe.
All right. Turning your attention now to what has been marked as Exhibit D. This is a two-page exhibit. Starting with the first page, would you please explain what this shows?
That's the survey plat showing the proposed outline of the well. We propose to drill the state 36-2, Bonanza 36-2 well using the existing well pad from the Bonanza 36-1 well pad.
All right, and on page 2, what does this show?
Page 2 reflects the well path, the wellbore path of the existing 36-1 well, which was drilled by KGH last year.
All right, this also shows that section 36 is a partial section, is that correct?
Correct.
All right. Turn your attention back to the first page of Exhibit D. Please explain what the plan is for the 36-2 well and why KGH wants to drill it.
after the results of the 36-1 well is encouraging, we are now planning to drill the 36-2 and trying to determine the optimal length economically for return on investment for this next well.
All right, and why are you asking for just a 50-foot setback from the section line with section 25?
Because we would like to see if approximately 1 mile lateral would be the most economic way to drain the reservoir and recover ultimate reserves.
All right, now turning back to the second page of that, can you provide a little more background on the 36-1 well, its distance, how long it was, successes, and how that impacts the drilling your proposed 36-2 well?
Well, it was a successful well. It was a shorter length lateral, only about a quarter of a mile. But it obviously gave us an encouragement from what we've seen from the 36-1 to propose to drill the 36-2.
And is that well drilled entirely on a state lease and within the boundaries of the state unit?
Yes.
Now turning your attention to Exhibit E, would you please explain to the board what this shows?
This is the oil and gas lease map showing the different ownerships in Section 25 and 36 and the mineral ownership.
All right, would you go through each of those? For example, let's start with the green area.
The green is the State Institutional and Trust Lands Administration lease we have. It's where we located the State 36-1 and where it will be using this existing well pad will also be where we propose to drill 36-2. The blue is the Robin's Egg blue is the BLM lease that's owned by TK Production Company. And then the yellow is the fee tracts, which we have leased 87.5%.
All right, would you go through the ownership of that fee tract?
The fee tract, the ownership is, mineral ownership is William Penn University 25%, Whittier College 12.5%, Earlham College 12.5%, Friends University 12.5%, Wilmington University 12.5%, TK Production Company, 12.5%, and Friendsville Quarterly Meeting of Friends, 12.5%.
And you either own or have all of those parties leased except for Earlham College as of last night, is that correct?
That's correct.
All right. Is there any spacing currently governing Section 36 to your knowledge?
No.
All right, thank you. All right, now I'm going to turn your attention to Exhibit F. There is no PowerPoint for this. This is a series of several documents that were signed by parties. Can you tell me, first of all, are these parties all the working interest owners in the state lease?
Yes.
As well as TK Production?
Yes.
Okay. For the board's information, this would be the required written consents under the exception location rule, subsection 1.2. However, you do have the control under the leases that were granted by all the parties in the fee tract, right?
Yes.
Okay, except for Earlham College?
Yes.
Okay, were you able to secure any written consent to the drilling of this well from Earlham College?
No.
All right, thank you. Turning your attention now to Exhibit G, would you please, this plat for the board's information would be required under R 649-3-3.1 and 3.3 to obtain an exception location approval. Please explain what this shows then.
Well, if we were to go under a statewide proposal right now in the setbacks, as opposed to drilling a 1 mile lateral, we'd have to do a number of short laterals to stay within the regulations the state has.
And by doing that, you would leave gaps of unrecovered resource?
Yes.
All right. All right, now turning your attention to Exhibit H. Again, there's no PowerPoint for this. Please explain what this is and what its significance that KGA wants to submit it.
This is an order with the Colorado Oil and Gas Conservation Commission establishing the setback spacing for and adjoining across the state line drilling and spacing for the same reservoir, the Mancos B formation, which sets back a 330-foot setback from the lease boundaries. And that's what it shows.
All right, so you didn't submit this to to show appropriate spacing, right? Is that correct? You were just trying to show that the setbacks are more lenient than the ones that you've requested?
That's correct.
All right. Is there, that order, does that pertain to about a 2,000 acre unit? Is that correct, too?
Correct. I believe it's 2,100 and some acres, I believe.
All right. Let's go to what will happen if the board grants this. What will KGH do with Earlham College before drilling this well? What's your intent?
Well, our intent is to work with as best we can to hopefully give them the opportunity to either lease to us or to participate, should they choose not to participate, under opportunity to participate.
Okay, how would you, what would be, how do you intend to split the share of costs between them and your partners between sections 25 and 36?
We would, using the 500-foot setback rule, where we're proposing, this ownership split would be the state Sitla tract would be, the fee tract would be 53.9%, and the state Sitla portion would be 46.1%. So they would pay their portion under the under that split.
Okay, and that's based on the 50-foot setback and including 450 feet of the southwest of section 25?
That's correct.
And would that be modified based on what you get the results of the well if necessary?
Yes.
All right. What is KGA's commitment to the board about seeking spacing with the well?
KGH is committed to seek spacing once the well is drilled and data is generated to reflect the appropriate drilling unit. Within 6 months, KGH will either seek spacing or report to the board that additional time and production data are required. Any adjustments can then be made accordingly.
All right, now I'm going to show you what is the certificate of service that was prepared by my office, filed as a pleading in this matter. Do you recognize the names that are shown on there?
Yes.
And who are those parties?
These are the co-lessees and working interest owners in the well and acreage.
They're also the lessors?
That's correct.
Okay. All right. And how are those names and addresses determined?
Through our internal records and also through the records of Uintah County.
And Sitla on the state lease?
Yes.
Okay. All right. Exhibit Z is supplemented are the true and correct copies of the return receipts or the USPS inquiries showing the status of those. As the board will notice, there was 2 that were returned, one having a bad address due to a miscommunication between KGH and Lear, and the other that was simply unclaimed by the party. However, those 2 parties with those mailings did provide the written consent that's reflected in Exhibit F, so they are consenting to the drilling of the well. With that concludes my examination of Mr. Hauptman.
Division, questions for this witness?
Yes, the division has a few questions for this witness, and with permission from the board, after I finish a few questions, I'd like to have Mr. Peterson ask some questions if he still has them. Is that okay?
No objections from the board.
Is that okay with you, Fred?
No, I don't have any objections, depending on the nature of the question of whether it's appropriate for another witness.
That's fair. Can you discuss more? It was mentioned that there's a Sitla unit covering part of Section 36. Can you discuss more where the Sitla unit boundaries are? Is it just in that one map that was provided?
And is it still in effect?
The Sitla boundary in this particular well we're proposing a drill includes all of the Sitla lease in 36, but does not include the fee tract in yellow, the west half northwest for 36, or any of Section 25.
Okay, but the Sitla unit is still in effect?
Yes, it is.
Okay.
Has it been recognized by the board as a spacing unit?
And has that been recognized by the board as a spacing unit? The Sitla unit?
Which the 36-1 well?
You go ahead and ask.
We were wondering if it's been recognized by the board, or is it just a unit set up within Sitla?
Yes.
Who recognizes this unit, in other words?
It's recognized by Sitla and the board, I believe.
No, it hasn't, not in the typical fashion like the board is used to suspending rules within a federal unit. There is no spacing currently within this, even though there's a unit involved.
Okay, and then on to the, to obtaining consent for the exception location. Could you please describe your efforts to obtain that consent for the unleased owners?
It's been rather extensive over the last year, yes. Primarily lack of one-way communication.
I realize that William Penn has since withdrawn their objection, but in their initial filing, they represented that they had never been, there was never consent sought.
Objection to that was a disputed point.
Anyways, it was mentioned or discussed in their filings that they had been, the offers received to lease, but never seeking of consent for the exception location. Is that accurate?
We had offered to lease, we were going to have a rebuttal witness come today, but we didn't have them come, the lease broker, because William Penn withdrew their objection. I think we were documenting, we attempted to reach them over 23 times to seek consent from them, and they, mainly, that was 100% non-responsive.
Right, for the leasing, but do you know if there was ever an attempt to get consent for the exception location?
Yeah, they've been non-responsive to anything we've asked. I can't, it's a one-way deal. So in negotiations with William Penn, we had responded, we're giving them all notification what we're doing. Giving every opportunity to respond. It's been a one-way conversation.
Correct, to lease.
Correct.
But there's no evidence of record to demonstrate you attempted to gain consent. And that's of concern for, in particular, the Section 25 area where the estimated or the proposed bottom hole location is only 50 feet from Section 25. That's why the exception location rule requires consent within that 460 area. And what I'm getting at is there's no evidence of record that you attempted to get consent from the Section 25 ownership for William Penn, only an attempt to lease.
Yeah, I did not request consent from them because we have never been able to be in communication with them.
Okay, thank you. In William Penn's representations, they mentioned that the initial offer was about $25,000 over 5 years. Is that accurate?
Correct.
And then, as of last night, William Penn has withdrew its objection because it has now leased. William Penn previously represented that another company had offered $125,000 over 3 years.
I'm going to object again to that. That's a disputed point.
I can't stipulate that we usually don't disclose what we pay, but in this particular case, I'm willing to testify that we paid them exactly what we first offered them, $125,000.
$125,000 or
no, $25,000, excuse me.
Over 5 years or 3 years?
It was a three-year period with a 2-year extension.
Okay. And then your Exhibit H, the Colorado order, how do you operate any wells in that pertain to that order?
Not in that order, no. Immediately adjacent to.
Okay, so in the general area?
Yes.
Okay. And have you sought spacing in those areas?
No.
Okay, and then did you have any other questions on that?
First of all, on Exhibit D, page 2, just in case there's confusion, what is shown here is the as-drilled path. That actually, I think the surveyor misdrew that. That as-drilled path terminates in the circle where it shows the bottom of the 36-1. not as shown. So it is, as you said, only about a quarter mile long, not a half mile long.
That's correct.
Yes. I just want to get that clarified. As you've stated now, only Earlham College remains unleased?
Yes,
What's their interest in that lease? Do you recall?
12.5% mineral interest.
So you have 87.5%?
Correct.
Okay. You mentioned you're looking at allocation. Now, we had thought, we're under the understanding, I think, that it was a 50-50. You are going to allocate at approximately 46 and 54%.
That's correct.
Now, that would be based, if my calculations are right, that would be based on completing no closer than 100 feet to the north line. Is that correct?
That's, that would be completing within 50 feet from the north line, so that we would be 500 feet, no closer than 50 feet from the north line, so that we would be, that's the reason we would say we're taking it into 25, 450 feet for,
Okay.
for the 500-foot radius.
Okay, so the 50-foot, that's a question. Your point that's 50 feet from the north section line, is that your bottom hole, or do you anticipate that being, say, your last production take point?
That'd be the last production point.
Okay, so you're 500 feet from the south line with your first take point, and you're 50 feet from the north line with your last take point?
That's correct.
Okay.
And why did you decide to go 500 feet from one section line, but only 50 feet from the other section line?
Well, we have it's a common interest in 25, 87.5% interest in 25 and 36. And so we're not encroaching upon a lease boundary, since we have the leases, except for 12.5% in hand. And what we're trying to determine here is that we're stepping out here. This is an exploratory unit. We don't know the optimal length of what is the optimal length to drill right now on an economic return, cash return on investment. And that's why we're doing this. We're pioneering out here, trying to figure out what the length is, what we're trying to do here.
So could you not have gotten the same length by going closer with a lower setback to the south, and then having that same lower setback to the north, say 300 on each end, and still approached your 1 mile lateral that you want?
Well, depending what we learn from this, we may come to the board in the future and ask for that. We just don't know right now. At this stage of the game, the abundance of caution, we're saying a 500-foot setback would protect relative rights. We're being more than cautious than they were across the state line in Colorado, where there was a 330-foot setback. This is a 500-foot setback, so we're being more than cautious on our end, conservative, so we don't impose and have any relative rights issues.
On the south end?
Right.
But not on the north end.
Well, we'll say, once again, we're within our leasehold interest.
Common leasehold interest, not identical?
That's correct.
Okay.
With some leaseholds remaining unleased.
Correct.
Okay. I think that's all I had. Did you have any other? Those are all the questions we have for this witness.
Board, any questions for this witness?
Mr. Chairman, could I just have a moment and may want to redirect the question?
Yes, Mr. McDonald.
All right, one redirect question. Mr. Houtman, the section directly below Section 36 would be Section 1. What is the ownership in that lease, and would that help explain why you're trying to keep a conservative boundary from that?
Yes, the lease in Section 1 is a federal BLM lease that's owned by Robert L. Bayless.
And therefore, you're trying to keep the setback so that you're not draining that lease, which has uncommon ownership with, unlike the fee tract. Is that correct?
That's correct.
Thank you. No further questions.
Thank you. Division, do you need any more time because of that redirect or any other follow-ups?
Just it's still unclear. While there's a different ownership to the south in the section below, there remains unleased owners in section 25 to the north. So it's unclear why the operator, petitioner wants to be very conservative with the BLM and very liberal with unleased owners to the north.
I would present that more as argument than fact testimony.
So noted. Any questions from the board for this witness?
Who is going to receive production from the 36-1? Yeah, the royalty
interest,
production.
that's 100% Sitla.
Okay, thank you.
Mr. Hanson? No. Any other questions for this witness? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Wingerter. Mr. Wingerter, would you please state your name and business address for the record?
Jeff Wingerter, P.O. Box 20066, Billings, Montana, 59104.
And what is your current position in relation to KGH?
I'm geologist with Hone Engineering, and Hone Engineering and KGH have an agreement and a partnership whereby we provide geologic and engineering services to KGH.
In particular in this Bonanza area?
Yes.
All right. In order to qualify as an expert, could you briefly outline for the board and the division your education, work experience, particularly any experience in the Uintah Basin or an analogous basin, any publications or certifications, and any other recognitions by state conservation commissions?
Yes, I graduated in 1982 with a master's degree from Eastern Washington University in geology. I've been practicing as a professional geologist for 40 years, primarily in the Rockies, mid-continent Kansas, and concentrating the last 10 years in the western Piceance and Uintah Basin with Hone Engineering and KGH. I have appeared before the board and accepted as a professional witness with Montana Board of Oil and Gas.
Mr. Chairman, with that brief testimony as well as his resume, I would ask that Mr. Wingerter be recognized as an expert in geology for purposes of this cause.
Division?
The division is satisfied that he should be recognized as an expert witness in this cause.
Any concerns, board? Seeing none, he is so recognized.
Thank you, Mr. Chairman. Mr. Wingerter, I'm going to show you what have been marked as exhibits I through L. Do you recognize these exhibits?
Yes, I do.
Were they prepared by you or Hone Engineering personnel with your review and input?
Yes.
And again, I would ask the board to just ignore the labeling of the exhibits, but again, the substantive material on here is exactly as it was filed with the board. Okay, turning your attention to Exhibit I, would you please explain to the board what this is and its significance?
This is the type log that is used for as a reference section for the Lower Prairie Canyon. This is an open hole log obtained from the pilot hole of the KGH MAR 3-3H, which is approximately 1/4 mile northeast of the 36-1 and just a shade over 1/4 mile from the proposed 36-2. This section highlights the Lower Prairie Canyon member of the Mancos B, and what is highlighted in green is what we call the Bonanza Zone, which is the target zone for the 36-1 and the 36-2. This target zone has proven to be very prolific and productive in the 36-1 and other wells in Colorado.
All right, just curious, why would you not use the log from the 36-1 well as opposed to this one for the type log?
The 36-1 well was drilled as a monobore, and there were no open hole logs run in that particular hole. in a later exhibit, we will show the directional survey gamma log that was corrected to TVD.
So you believe that this type log is an appropriate reflection of the targeted zone for the 36-2?
Yes.
All right. Turning your attention to Exhibit J, would you please explain what this is?
Exhibit J is a line of section that shows the points of correlation for the next exhibit.
All right, and turning to that next exhibit, which is Exhibit K, would you please explain what this shows?
This is a log section of approximately just over 4.5 miles in length, starting in Utah at the KGH 2813. And it does show the gamma log I indicated, talked about earlier, from the 36-1 and then terminates in the 3-3H. And it shows the continuity of the target zone being that bonanza zone. And it also shows the apparent thickening of the bonanza zone in the 36-1 and hopefully the 36-2. And it also shows the location, not to scale, of the 36-2.
Right now, turning your attention to what is Exhibit L, would you please explain to the board what this shows and its significance to the request?
Exhibit L is a structure contour map on 100-foot contour intervals drawn on the top of the bonanza zone, and it shows a moderate dip to the northwest of approximately 500 feet per mile.
And what's the significance of that?
It shows that the proposed location, the proposed borehole of the 36-2 will be down dip and hopefully in a more liquid-rich portion of the bonanza zone reservoir.
All right, is it your expert opinion then that the correlation and continuity of the Prairie Canyon member supports the drilling of the 36-2 well as proposed?
Yes.
Mr. Chairman, that concludes my examination of Mr. Wingeter.
Division?
Yes. So in your work with KGH, with petitioner, how many wells have you had a chance to view or help operate?
About 30.
Perfect. And in discussions leading up to today, it was represented that KGH has found a 1 mile long lateral horizontal to be best. Has that been your experience in this formation?
As shown in the 3-3H, because that's approximately 1 mile.
Okay. So you have a fair amount of experience dealing with this formation, leading you to believe that it should be 1 mile in length, right?
Yes.
Okay. And you anticipate this well being productive?
Yes.
The existing well and, the 36-1, which I might call existing well, and the proposed well, 36-2, they're going to be draining from the same resource. Is that correct? From the same reservoir?
Yes.
Perfect. And in the filing, it's represented that the initial production from the existing well is promising. Can you tell me more about that?
I would propose that Mr. Hone address that in his engineering
That's fine.
presentation.
That's totally fair. Is it possible to, based off of the comparisons that you have from that well that's about a 1/4 mile away, is it possible to determine the reservoir's physical characteristics?
Subjectively, yes. We do not have open hole logs on the 36-1, but I was present and did watch the cuttings, so I can gladly provide you with physical observations of the cuttings.
So you'd be able to tell the porosity and permeability of the sands?
No, not from visual observations, no.
But from the well that's about a quarter mile away, would you be able to extrapolate that data?
The porosity, yes. Permeability, no.
Okay. And why was the 36-1 well drilled in a way that you couldn't capture that data? You couldn't understand that data?
There were no open hole logs run. It was a monobore. We just, without running any intermediate casing, we just drilled the entire length of the well and never ran open hole logs. All we needed were directional tools, and we could obtain directional information from the logging while drilling LWD tools, i.e. the gamma tools.
So was it a business decision then to drill in that way so that you couldn't get the data?
And economic, yes.
Okay. Based off of the 36-1 well, as well as that well that's about a quarter mile away in Colorado, are you able to tell the size and type of the producing formation?
We never drilled the entire thickness of the Bonanza zone in the 36-1. Therefore, I cannot tell you the thickness as compared to the 3-3. However, I can tell you that the productive zone, the Bonanza zone in the 36-1, is at least twice as thick as it is in the MAR 3-3.
So would it be safe to say you have an idea of the size and type of the producing formation, even if it's not exact?
A rough idea, yes.
Are you able to ascertain whether it be from the 3-3 or the 3-1 well, the pressures within the reservoir, such as the strength and nature of the reservoir?
Again, I'll refer back to Tom on that for his engineering.
That's totally fair. Did you have any questions? I might ask a couple. Yeah.
So you're looking at a formation, I guess I'm trying to get a feel for the variance of that formation across this area, this Bonanza formation. So you're looking at pretty much regional dip with no distinct structural features, is that correct? And do you expect a lot of variance in the rock properties, say over the distance of a mile here? Or are they going to be pretty consistent over this entire area?
We did see significant difference in reservoir quality based on cutting appearance in the 36-1 as compared to the 3-3. The 36-1 had much better quality sandstone. It's common that the Bonanza zone is typically a very fine to fine-grained sandstone. In the 36-1, we did see medium-grained sand. That would indicate that we have better reservoir characteristics.
Meaning probable higher porosity, is that what you mean? And maybe better connectivity between the pores?
Probably, yes. Better porosity and permeability.
Okay. That's all for me, thanks.
Those are all the questions we have for this witness.
Board, any questions for this witness? Yes, Mr. Church.
So, Mr. Wingert, on the cross-section on Exhibit K, where you say that you have twice the thickness in the 36-1, did you drill vertically through the formation? Is this true vertical depth that you're showing on the thickness?
Yes, on the log, on the cross-section for the 36-1 is corrected for true vertical depth, and it is from the gamma tool on the directional drillers.
Okay, but you were drilling through the curve.
Correct.
through this. So that thickness, this gamma ray has been corrected back to true vertical depth.
That is correct.
So you do see that as a depositional change, even though there's not a structural change, you have a consistent dip. You're seeing a actual depositional difference in the formation.
That is correct. And that is why the structural map that was presented in an earlier exhibit and later exhibit uses the marker on top of the bonanza zone as opposed to the base of the bonanza zone, because the base of the bonanza zone was never encountered in the 36-1 well. Whereas the marker, that top of bonanza, is a very consistent marker across the entire basin.
Okay, and then another question, you talk about looking for more liquid rich or a different property in the liquids. So is this solution gas that's produced with the oil out of the 36-1?
It's predominantly gas with some oil, and yes, it is solution gas. Our intent is to get lower in structure and pick up more oil.
So you're hoping for a difference in the GOR?
Yes, that's what we're hoping for, yes.
Okay, and in the 36-1, you're presently hooked to a pipeline then?
Yes.
With the gas. And so it was mentioned earlier that on the 36-2, that within 6 months of production, you'd be able to ascertain the economics on this. So you don't see a problem with an immediate hookup when you start the well on production?
Oh, no, by drilling the 36-2 from the same pad, the surface facilities are just
all
right
in
there.
place. Okay, and contractually, that would be all handled
Yeah.
with your purchaser?
Correct.
Okay, thank you.
Any other questions, board? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Hone. Mr. Hone, would you please state your name and business address for the record?
Name is Tom Hone, that's H-O-H-N. Hone Engineering is my company. We're at P.O. Box 20066, Billings, Montana 59104.
And what's your current position in relation to KGH?
My firm consults for KGH and in terms of geology as well as engineering operations. And I am also, my production company, Bermuda Energy, is a working interest owner in this project.
Right, turning your attention to what have been marked as exhibits M, N, and O for purposes of this cause. You recognize these exhibits?
I do.
Were they prepared by you or Hone Engineering personnel with your review and input?
They were.
Right, turning your attention to Exhibit M, please explain to the board what this shows and its significance to this request.
This exhibit shows the production curve for the MAR 3-3H well. That's the well that Jeff mentioned is a mile or so, or some distance from the east of the lands that we're talking about today. This is our analog well, the closest analog we have, and it's the well performance that we hope to achieve, similar performance out of our Utah project.
And you use that for an analog. It's there's what 10 years plus?
10 years of history. It's got about a 3,500-foot lateral. Its EUR is estimated to be 142,000 barrels of oil and 3 BCF of gas.
All right, turning your attention to Exhibit N then, please explain what this shows and its significance.
Exhibit N is the production curve for the Bonanza State 36-1. You can see we've got about 7 months of production history there. It's been very erratic through the winter, a lot of tough roads over there, and we had startup issues with flowback after frac, pipeline issues, line pressures gave us some problems. So the production history, in my opinion, is too erratic to draw too many conclusions from. I did perform projected some reserves for the well where I used the performance of the 3-3H. That profile curve just slid it down to the initial rates what we're seeing in the 36-1. And those reserves project to 54,000 barrels of oil and 1.6 BCF of gas.
All right, now turning your attention to Exhibit O, please explain what this shows and its significance.
This is my attempt to estimate drainage area. The top part there is just the lateral of the 36-1, the geometry of how it's laid out, about a 1,500-foot lateral. If we're draining 500 feet, it calculates to be about 34.4 acres. 50-foot zone thickness gives us 1,722 acre-feet of reservoir. I did oil in place calculations using the rock properties taken from the MAR 3-3 well, as well as some other vertical Mancus B wells just across the state line. Average porosity of 13%, water saturation 41%, and a formation volume factor of 1.52. Oh, I'm sorry. Okay. Those parameters calculate an oil in place of 391 barrels per stock tank barrels per acre foot and 1.9 BCF per acre foot. Excuse me, 1.1900 MCF per acre foot. Taking the reserve estimates that I've talked about in the previous exhibit, the EUR for oil, 54,000 barrels and 1.5 BCF of gas. Applied an estimated recovery factor, 12% for the oil, 70% for gas. Gives me an oil in place calculated of 450,000 barrels of oil, 2.3 BCF of gas. When I go through the acre footage I have and such, I calculate an area of about 23 acres drained, and that would relate to 334-foot drainage radius.
All right, let's again, the purpose of this is to try and not show the drainage for purposes of spacing, right?
Right. There's
a lot of speculation and assumptions put into these calculations. Is that correct?
That's correct. And
is the purpose of this then to show generally that the setbacks are conservative enough?
Yes.
All right. You've had experience in Colorado. What's your experience with the Colorado Mancos wells? Have you ever seen anyone drain beyond 500 feet or?
I've not. I've looked at a lot of Mancos B wells throughout Colorado or Rio Blanco County, and I've yet to find one that I could say drains more than 500 feet.
All right. So just to confirm then, is the estimated drainage of the 36-1 well, in your opinion, not extend beyond the boundaries of that leasehold?
That's correct.
And is it your expert opinion that the requested setbacks of 500 feet should be more than adequately protective of the adjacent owners that don't have common ownership?
Correct, yes.
And is it also your expert opinion at this point that there's insufficient data to seek any appropriate spacing for the 36-2 well based on your assumptions and all that that are shown in these exhibits?
That's correct.
Right. Mr. Chairman, that concludes my examination of Mr. Hone. Oh, I take that back. Mr. Hone, you heard some of the questions from the division. Is there anything else you want to address based on those?
One thing I'll mention is the terrain that we're dealing with out here is really rugged. Our surface locations are very limited, so we've got to get as much footage out of a wellbore as we can. Drilling short laterals is not going to, it's going to leave a lot of oil and gas in the ground. So that's one of the compelling reasons for why we propose what we're proposing.
Stay close to that mic here.
So,
Okay.
with the board's permission, oh, go ahead.
No, I was just going to say that concludes the examination. Thank you.
Okay, now over to you, Division.
Thank you, Chairman Borden. So on that note, it's a little curious, why was it decided to drill a short lateral instead of a long lateral for the 36-1?
Mr. Hauptman would better answer that, but I think it was economics.
Okay. And is there information that you will get from the 36-2 well that you could not have gotten from the 36-1 well?
Well, we do plan to drill a pilot hole and run open hole logs on this well.
Okay. Based off of the 3-3 well, are you able to get an idea of the pressure within the reservoir?
We have pressure data on the 3-3. We don't really have any good pressure data on the 36-1, but it's, again, after reviewing a lot of Mancus B wells, the pressure is pretty consistent through that reservoir.
So you feel like you could estimate the pressure?
Yeah, pretty close.
Okay.
So am I correct, your reservoir volume factor is at a 1.5% that you, or 1.5 stock tank barrels per reservoir barrel, is that correct?
Yep.
Which is high.
Yep.
Is this a volatile oil? Do you know if is it a retrograde system, or is this an oil system with volatile oil, or is it do you use PVT data or treat it like a black oil?
I don't know if it's properly called a volatile oil. It's a light oil. A lot of paraffin in it.
Mm-hmm.
It's and a lot of wells have pretty high GORs. So
Right, so it could be a volatile oil.
yeah.
And as Mr. McDonald mentioned, there's a lot of estimates that have gone into this.
Yes.
You do feel that your recovery factors estimated the 12% and the 70% are reasonable for this type of system,
Yes.
for what we know about the system? Okay, thank you.
Those are all the questions for this witness.
Board, any questions for this witness? Yes.
So my question would be on the frac design that you had on your 36-1. Will you be using a similar frac on this longer lateral?
That's somewhat undecided yet. I think we're probably going to use a frac more similar to the 3-3H well. Try to model that performance as best we can.
Okay, and with the terrain and the pad size you've got, you can handle all the equipment with doing a large frac?
Yes, yes.
Okay, and that, when was the 3-3 drilled? Is that?
3-3H, the Colorado well?
Yes.
That was about 10 years ago, 2014, I think, yeah.
And so I was wondering then, frac designs have improved a lot since in the last 10 years, but you're going to be trying to mirror something like that well?
We've been pretty pleased with that performance, and you know, don't see need to change too many things in there. Although we'll drill a well and design our completion at that point. But
okay. So on the 36,
in terms of the proppant and size of job and such, I think the size of the stage, I think we'll stay pretty close to that. We'll probably have more stages in the 36-2 2, but as I said, that's yet to really be decided.
So, and that was what interests me about the 36-1, whether you were attempting some duplication of the 3-3.
No, that frac was a new idea that I think we can do better on.
Okay, and that's what I would assume, that you're expecting better performance because of a different treatment also than the 36-1.
Correct.
Okay, thank you.
Any other questions from the board? Yes, go ahead.
Okay. I may have missed this along the line, but how many stages did you do on 36-1?
36-1 was 9? 9 stages.
9 stages, and you're going to do, well, you haven't drilled 36-2 yet, but you're going to do
It's
more.
basically going to be 3 times as long, so it'll be at least 3 times as many stages.
Okay.
4 times as many, probably.
Okay, that's cool. And other than the 3-3 and the 36-1, how many other wells do you guys operate in that general area?
About 35 right across the border in Colorado.
Okay.
Yeah.
Good. Okay, thank you.
Back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, that concludes our presentation in chief. At this time, I would move for admission of exhibits A through O and Z as supplemented.
Division, any concerns?
No.
Okay. Exhibits A through O and Z as supplemented are admitted as evidence.
Thank you, Mr. Chairman. With that, I'll reserve time after the division's presentation, and if the board still desires more oral argument on the issues that were presented in their objection and on the legal end of it, I'm happy to do that.
Thank you. It's over to you, Division. Oh.
Have you ever encountered these guys along the line, any player along? I've seen their name, but I've never.
No, personally,
crossed paths.
I have seen these gentlemen before. Drilled in Colorado. I've drilled in the Macros Beach before.
Since it's Board Member Hansen's last board meeting with us, I thought I'd get fancy with some PowerPoint slides. I aim to please. But on that note, I also need to clarify a few of the numbers that are going to come up in here have changed since the leasing of William Penn's. So Mr. Ellis has been kind enough to run those numbers, and he'll provide an oral clarification of the numbers that have changed. Additionally, in speaking and preparing up to today, it was asked how revenue and expenses were going to be shared, and it was understood, at least before today, that it would be on a 50-50 basis. That has been clarified and he can provide some adjustments on those as well. So some of the numbers are not accurate, but we will clarify. In my presentation today, I will likely refer to the 36-1 well as the existing well and the proposed 36-2 well as the proposed well, just for clarity. The board's task at hand is not necessarily the easiest one. Under statute, it's to authorize and provide for the operation and development of oil and gas properties in such a manner that a greater ultimate recovery of oil and gas may be obtained, and that the correlative rights of all owners may be fully protected. So you're maximizing recovery on the macro scale, and you're protecting all correlative rights on the micro scale. There are 3 issues presented today, and the division is presenting these issues as well as presenting potential cures for these issues. The first one is a substantive flaw, and the cure to that flaw is to space the area or obtain consent from the remaining unleased owners. The second issue is a procedural deficiency, and the cure is, rather than an exception location, petitioner should refile requesting a suspension of the statewide spacing rules. The third issue is that petitioner's request for agency action will likely drain from the adjacent section to the north. The southern setback is very conservative, and the division is more than satisfied on that setback, but the northern setback causes some heartburn. And the cure is to require a setback that will protect all correlative rights. First, on the substantive issue, petitioner's RAA seeks a second well in a small, irregular section without spacing and without consent from affected mineral interest owners. They can cure this flaw by either spacing the area or obtaining the consent required under rule. Let's start out by looking at what the code provides. So Utah statute says the board has the authority to regulate the spacing and location of wells. The board can establish drilling units that overlay a pool, and only one well may be drilled for production from the common source of supply, except when the board authorizes more than one well in a drilling unit, provided the board finds engineering or geologic characteristics justify the drilling of more than one well in that drilling unit, and the drilling of more than one well in the drilling unit will not result in waste. Here, the existing well and the proposed well will both be drilled from and produced from a common source of supply. That's been noted by the experts for petitioner. Under the statute, only one well should be draining from this common source of supply until the operator seeks authorization for additional wells in the drilling unit. The board's rule implementing that code states a temporary 640-acre spacing unit consisting of the governmental section in which the horizontal well is located is established for the orderly development of the anticipated pool. And I'd just like to point out again, this is an irregular section. We're talking about less than half of a 640-acre section. The board's rule establishes that you get one well in a 640-acre area until you come back with more information. And here, it's a 277-acre area. They already have their well, and they're coming back for a second without providing that information. Further, when the division approved petitioner's APD for the existing well, the division listed within the conditions of approval an instruction or request that petitioner return and seek spacing before any future wells in Section 36 could be approved. Drilling units are meant to be modified over time as more data becomes available. They're not meant to be stagnant. And that is shown in the statute, in the way that the legislature set things up. So if you look at Utah Code Annotated 40-6-6, the board may modify an order that establishes drilling units for a pool to provide for an exception to the authorized location of a well. And we're going to talk about the exception location in just a minute. So the board has provided that in rule. The inclusion of additional areas which the board determines overlays the pool, the increase or decrease of the size of drilling units, or the drilling of additional wells within drilling units. So essentially what the statute is getting at from the outset is when there's a reservoir, when there's one common source of supply, generally it should be one well until we get more information, and then we start adding more wells. The board went through formal rulemaking and made a determination that a 640 temporary spacing unit should be established every time you go into a new area. So that's what's happened here, only it's a 277. So the division has already kind of allowed something to go through that arguably shouldn't have, but we were happy to do it. We want to see this area get produced. We just want to see orderly development. So petitioner can cure their substantive flaw by spacing the area. Spacing can be modified as more data becomes available. Their second option for curing this substantive flaw is obtaining the requisite consent. And at this point, it sounds like there's really only one owner that needs to provide consent. So they can obtain an exception to the temporary spacing unit established under Utah Code Annotated R649-3-2. They must obtain written consent from each owner within a 460-foot radius of the proposed well location. And this is going to kind of bleed in, the substantive issue that we have bleeds into the procedural deficiency that gets raised in our filing. And I think there's a little bit of confusion of what's actually required. So let's look through the exact language and kind of piecemeal this. So statewide spacing rule implements the temporary 640-acre spacing unit that we've been talking about. And that gets laid out, and you can get an exception to that, to the 640-acre spacing unit, may be approved upon proper application pursuant to 649-3-3, exception to location and siting wells, or 649-10, administrative procedures. So there are two options to get an exception to that requirement of the temporary spacing, the 640 unit. You have two separate options. The first is the rules under 649-3-3, which is specifically an exception location. And the second option is a more general option, and that would be just suspending the requirement entirely. In this instance, let's talk about the exception location procedure, because that's what petitioner has relied on. They have not filed a general RAA requesting suspension of the rule. They've only filed a request for this exception location. So looking at that exception location procedure, an operator seeking an exception to a location must submit an application and written consent of all the relevant owners. And the specific language reads, the division shall have the administrative authority to grant an exception to the locating and siting requirements of 649-3-2 after receipt from the operator of the proposed well of the following items. And it lists a few things, and then it says written consent from each owner within a 460-foot radius of the proposed well location when such an exception is to the requirements of 649-3-2. If the division does not approve a request for an exception location that is complete, including the written consent from all relevant owners, the operator may seek the exception location from the board. And the language for that is, if for any reason the division shall fail or refuse to approve such an exception, the board may, after notice and hearing, grant an exception. Now that language, such an exception, is really important here. That such an exception means it needs to be complete. They don't get to just come before the board if they're unable to provide the basic requirements of an exception location. They need to they need to go before the division with a complete application. If the division refuses to grant an exception location after receiving a complete application, then they can come before the board. They don't get to just come before the board without fulfilling the basic requirements. Their second option would have been to just request a suspension of statewide spacing rule under R649-10. Petitioner did not seek this relief. Okay, so just to recap these first two issues. Petitioner's RAA is substantively flawed and there's a procedural deficiency. The statute anticipates spacing early and modifying as necessary as more data becomes available. The statute allows for one well draining a common source of supply, which has been established here, unless the board makes findings to allow additional wells, i.e. spacing. The existing well and the proposed well will both drain from a common source of supply. Statewide spacing rule implements a temporary 640-acre spacing unit, and petitioner wants two wells in a 277-acre section without providing the consent required for an exception location and without requesting suspension of the rules under R649-10. The exception is allowed with consent from owners or suspension of statewide spacing, neither of which are present here. Okay, the third issue that we want to talk about today deals with correlative rights. And petitioner's RA will likely, by their own estimates, drain from the adjacent section. So correlative rights are defined as the opportunity of each owner in a pool to produce from the owner's just and equitable share of the oil and gas in the pool without waste. And again, just to reiterate the board's task at hand, one of the things the board has to always keep in mind is that the correlative rights of all owners may be fully protected. Correlative rights can be defined or they can be undefined. Defining correlative rights under Utah law, the mechanism for defining correlative rights in a pool of oil or gas is a spacing order which establishes field-wide drilling units. When the board spaces an area, it needs to consider the reservoir's physical characteristics, which is, the pressure within the reservoir, porosity and permeability of the sands holding the hydrocarbons, size and type of the producing formation, and the available technology for extraction, economic considerations including market prices and costs. And that's found under the Utah Supreme Court case Cowling v. Board of Oil, Gas, and Mining. Now, what's interesting here is, based off of the information available, they're able to provide all of those things except for one. So they're able to provide, the pressure within the reservoir, the porosity of the sands holding the hydrocarbons, the size and type of the producing formation, and certainly as an operator, they know the available technology for extraction and economic considerations, including market prices and costs. The only thing we lack here is permeability. And they could have obtained that in the 36-1 existing well. They chose not to obtain that data. They were told to by statute, they were told to by regulation, they were told to by the division. They failed to do it. Why are we rewarding them with a second well if they haven't done what they're supposed to be doing? If correlative rights are undefined, the board rules are in place to provide some level of protection. And that's true with the temporary 640-acre spacing unit, as well as the 660 feet setback from boundary lines of leases not committed to the drilling of a horizontal well. Just to look at these one last time, if they'll come up. It didn't. Oh, shoot, it's not coming up there. These are exhibits that we've already gone through today. Just this first exhibit submitted by petitioner indicates a bottom hole location 50 feet from the north section line. With an estimated drainage radius of 334 feet. So they'll be draining about 284 feet into the southwest corner of section 25, where the ownership is mixed and some of that ownership is unleased. And this is where I'm gonna need Mr. Peterson to correct some of these numbers because they are not accurate anymore. Can you go ahead and explain?
Yeah, if I understand correctly, two or three things have changed here. One thing Mr. Hopman said, and it's probably, in my opinion at least, the correct thing to do, is they would have interest in this new well proportionate to the amount of completed interval on each separate lease. Is that correct, Mr. Hopman? Yeah, I got that right. And you mentioned that would be roughly a 46-54% split, with 46% being on what I will call the Sitla lease and 54% roughly on the fee lease.
That's correct.
Okay, so if I put those numbers into effect, all I can say is, so TK's interest in, from my just kind of on-the-cuff calculations and some rounding, looks like where you have 83% in the Sitla lease, TK has 83% working interest. Now you have leased 87.5% in what I'll call the fee lease.
That's correct.
So your actual interest in the well, your working interest, will be over 85%.
Well, on the fee tracks, this is a lot of moving parts here. The leases we've acquired, the ownership will be common with the fee tract and the state Sitla lease, where TK will have 83%, and then I will also have 83% of the fee tract also. When assignments get caught up, where these leases have just came in or just coming in now.
Okay, so my point might not be correct here now because, yeah, our interpretation was, admittedly, that you had other lessees in the Sitla lease who basically would have no interest in the fee lease.
Yeah, that's not correct.
But that's not correct
The
anymore.
interest will be common.
And that was our point, was those interests aren't identical, and those other lessees in the SITLA would be getting a share of any reserves drained from the fee lease in Section 25. And that was the point I
Right.
think we were trying to make.
Right.
And they won't be identical, but we don't have that quantified.
Right, no, I'm on my honor. They're,
Well, and I can't
they're my
quantify
partners.
it
I owe
without
to them,
knowing
yes.
what you know.
Yeah.
So, thank you.
They'd hang me.
Yes.
Petitioner's reply states, with respect to the Colorado order submitted as KGH's Exhibit H, it was not intended to support spacing of the lands at issue. Rather, it was submitted to reflect their proposed setbacks are sufficiently protective. And there's still some moving parts here and a little bit of confusion, but it's certainly not protective on the north end, where it's a 50-foot setback, but a drainage of 334 feet. Just as a recap, petitioner seeks a 50-foot setback, estimated drainage of 334 feet, significant ownership interest in affected area remain unleased. While not defined, correlative rights will be impacted by draining an area without compensation to the corresponding mineral interest owner. Recap, petitioner's request for agency action is substantively flawed. The cure is to space the area or obtain consent from relevant owners. Petitioner's request for agency action is procedurally deficient. Cure, rather than exception location, petitioner should refile requesting a suspension of the statewide spacing rules. Petitioner's RA will likely drain from adjacent section. Cure requires setbacks that will protect correlative rights. And then that's the end of our presentation in chief, if the board has any questions.
Board, any questions for the division?
Okay, for the division, do you consider where this well is, the 36-2, do you consider that the Uintah Basin or Piance Basin?
Or Douglas Creek Arch?
Oh, or is it part of the arch? Yeah, that's true. Yeah. It's that, okay, it's,
You know, I don't know that I'm qualified to answer that question. That might be for a geologist, knowing the basins or how those basins are defined. But being the Mancus, most of what we have, you know, we don't produce from the heart of the Uintah Basin, really from the Mancus, like this. So it's along the edges of the rims of the Uintah Basin, or in the arch, like you said. So I don't know if I would refer to it as Uintah Basin, but again, I don't know that I'm qualified to answer that question, Mr. Walker.
might be better to have.
Just,
what do you guys think? Or is it too fuzzy?
If I may, I would suggest that it's more like the Piance Basin than the Uintah Basin because of the productive interval. The Uintah Basin typically produces from the, at least in the close proximity to the subject area, typically produces from the Wasatch and basically the Wasatch, whereas the Piance Basin typically produces from the Mancus and the Mancus B in Castlegate. So that's my 2 cents worth.
Okay. Well, and I've been curious about this, but we're asking the division, do you know what the spacing is on the other side of the border, what Colorado was granted to the operators in that region?
the order that petitioner has filed from Colorado indicates that there are about 37 wells spaced in the sections adjoining Section 36.
I'm sorry, but what?
If I may clarify that, Mr. Houtman testified that that order pertains to a 2,000-plus acre unit as opposed to an individual drilling unit for one well?
So it leaves the potential for 37 long lateral horizontals or
Per section.
what you call it, vertical wells on a 40-acre basis. Correct.
Okay.
Mr. McDonald, do you recall, and maybe Mr. Hoffman would know that, but yeah, the unit in Colorado, was it for vertical wells only, or was it spaced for horizontal wells?
Horizontal wells.
Okay, thank you.
Yeah, it allowed for both, is my understanding. And that's kind of one of the problems here. This isn't somewhere out in the middle of nowhere that we don't have any information. This is right next to a township that is spaced. This is somewhere where petitioner has a well a quarter-mile away in Colorado and another well 1,000 feet away. They know what's going on here.
If Mr. Helpman can clarify that, his well is not spaced.
No, I have, we have not spaced the area in Colorado.
Right, but the exhibit that you supplied is a spacing order directly on the other side of the state line. Is that correct?
By a different operator, but yes, it is. The provision of that, the only reason we provide that for informational purposes, where they can drill numerous wells within that 2,100 acre lease, but no closer than 330 feet from the lease boundaries.
Correct.
Okay. Any other questions for the division? Mr. McDonald's going to get a chance to respond, and then we can probably do some follow-up questions after that.
Yeah, my question is for the division. At least one question. To clarify, on the north end of 36-2, what is your recommendation on the setback?
There has not been enough technical information for us to really determine that, like we have elsewhere in the heart of the Uintah Basin. The only information we have is what was presented by Mr. Hone, saying 330 feet of potential drainage. And that's really all we have to go by as far as provided technical information. There is no fracture information, there's no permeability, and we would need the viscosity and good numbers for porosity, good numbers for permeability to make that determination. So we do not have the information available, in my opinion, to technically assess that.
And neither does the applicant, is what you're contending right now. Okay, thank you.
But they don't have the information because of their choices with the 36-1 well. They could have obtained that information in compliance with the APD that they received.
So what is your solution if they are unable to obtain that information by methods that were not of their making? What would you recommend?
A more conservative setback to the north.
Okay.
At a minimum. And then a requirement that they do come back in space within 6 months as they said they would. And yeah.
So essentially you're saying that it's the division's position that in the lack of information that a spacing order is required to go and get additional information? Or did I misunderstand that?
I mean, that's what the statute seems to contemplate, is that you should be coming in and spacing, and then as needed, as you get more information, you should be modifying those spacing orders. So yes, the operator should be seeking spacing based off of the information that they have available in Colorado and potentially obtaining more information from their existing well, seeking spacing, and then if the setbacks are improper based off of that spacing and need to be either reduced or what have you, then come back before the board and modify that spacing.
Okay. I think I understand the division's position a little better. I guess I do have one more question, and it's regarding the exception. Remind me again who it was that you could not get the exception permission from it was William Penn. Is that correct?
Earlham College.
Okay.
It was originally William Penn and Earlham College, but William Penn, with last
Right.
night, it was withdrawn. Yeah.
And Earlham College has been non-responsive. Is that correct?
They've been responsive, but basically said they weren't going to do anything, and they never filed any response to the request for agency action.
So you really can't say that they haven't or have or have not given any kind of permission for the exception because they're not responding, essentially. Okay, thank you.
Division, I have a question for you on that. So Earlham College, because they have not responded, how will they be harmed by this new well if it were to be drilled and produced?
What's troubling in this instance is the facts that came out from the allegations of William Penn. And Mr. McDonald has now noted several times that is a contested point of fact. And so I'm not going to claim that it's a fact. I'm just going to say what's been represented. According to William Penn, the petitioner never sought consent for the exception location. They only sought to lease the interest, which are different. They're two different things. And the issue here is that not only was there never an attempt to get consent from William Penn, but also, according to William Penn at least, the offers to lease were about 20% of market value to lease that area. Again, this is an objected point of fact.
It's irrelevant from the standpoint they have now agreed to a lease with the terms.
So,
noted.
What I'm getting at is it's troubling that we're going to allow petitioner to drain the resource of somebody who has been unresponsive when, if taken at face value, petitioner has acted the same way towards Earlham College as they have towards William Penn University, meaning they have never sought actual consent and they have only sent lowball offers. If that's the case, it might be understandable that there has not been a dialogue and a legitimate communication back and forth.
May I make another comment on that?
Yes, Mr. Hanson.
Is there any evidence that the division has that the college was contacted and didn't respond? Or I mean, what you're saying is by their action with William Penn, you're saying, well, then they were probably acting the same way with this other entity, but we don't have any evidence of that.
Correct. We also don't have any evidence from petitioner that they tried to seek consent. They failed to provide any evidence, not only regarding, William Penn, but also Earlham College. And a careful examination of petitioner's reply to the objection from William Penn demonstrates that they never contested that, right? If they had sought to get consent from the owners, why aren't they providing evidence? It's not on the division to provide evidence of a negative fact. It should be on the petitioner who's seeking this act.
I object to that whole characterization of that testimony. You heard Mr. Hoffman say they tried 23 times with William Penn and they were unresponsive.
And I tend to see that.
Sustained.
I agree with his objection, and I think that if I'm trying to reach somebody who has no interest in responding, why would I ever ask for an exception? Because they're not going to respond. I can understand their frustration, and William Penn chose not to be here today and to defend their position, so I'm not sure how the division can make that leap that what happened with William Penn is the same or expected result of what happened with the other party. I feel very uncomfortable with that leap.
And that's very understandable. The issue comes if you read the rule as it's written, consent is required. And that's whether it's before the board or the division.
But if they're not responding, how do you get that consent?
Then instead of requesting an exception location, you make a request for agency action to suspend that requirement, which was not done here.
Okay, I understand your argument.
It's a procedural issue that petitioner has caused.
Any other questions for the division? Huh?
I don't know
Ms.
if this is
Garrison.
for the division or for Mr. Houtman, but I can't tell exactly from the survey plat and Exhibit E, does any part of the wellbore go across the fee lands, or is the entire wellbore on the Sitla lease?
The wellbore will be half under the Sitla surface and minerals. That would be the west half southwest quarter, and then the west half northwest quarter, it will then go, the wellbore will go up into that, and 50 feet
Okay.
from the section line.
Okay, so it does go on, the wellbore actually goes on to the yellow lease?
Yes.
Okay.
Chairman Borden?
Yes.
Just one more comment to Board Member Hanson. You raise a really good point. And there is a way to deal with recalcitrant mineral interest owners who refuse to cooperate and participate, and that's spacing and compulsory pooling. It shouldn't be through an exception location that somebody's minerals get drained without their permission. That's what the division is worried about. You are absolutely right that it's a bit of a stretch for the division to assume petitioner acted the same way with one of these mineral interest owners as it acted with another. However, at the end of the day, exception locations are not the proper avenue or procedure for dealing with a recalcitrant owner.
There will be time for more questions.
Go ahead. I have a question for division.
Oh, for division, go for it.
So procedurally, you're saying that the well was not permitted through you and should have been permitted by you before this even came before the board. Is that correct?
For this proposed well,
Yes.
yes, if petitioner could clear the substantive hurdle of obtaining consent. They could not clear that hurdle, and that's why they tried to come directly before the board. Procedurally, they should have, if you go to the rule, an exception to the temporary 640 acre spacing unit may be approved pursuant to section R649-3-3, exception to location and siting of wells. That's what they did do, and it requires consent, whether it be by the division or the board, or section R649-10. So there are two procedures that they could have chosen to take. They took the one that required consent despite not having the ability to obtain that consent. They should have gone with the other procedural route and asked for a suspension of that requirement.
So hypothetically, if there were a third approach, if the 36-1 were shut in or temporarily abandoned, there would be no unit there, or would that drilling unit still be there, or could they come in and drill the new well if the other well was temporarily abandoned or suspended?
Yeah, so under the statute, it says that only one well can be draining from this common source of supply. So your hypothetical, if it was fully plugged, absolutely, the petitioner could come in and request this new well.
Okay, but
not with the current setback. Sorry, that was my advice from people
right,
much
with
smarter
current
than me.
setbacks. But in your estimation, it would have to be fully abandoned, not temporarily abandoned. If it were temporarily abandoned, not producing.
That's a really interesting question. Let's look at the statute. Only one well may be drilled for production. So yeah, it would have to be plugged because the other well would still be drilled under the statute.
Thank you.
I believe we are temporarily out of questions, though I'm sure more will come up shortly. Mr. McDonald, do you want to respond?
Oh, yeah.
I didn't think you did, but okay.
Everything that the division has raised again today has been rebutted in my reply memorandum. I'm going to hit some of the highlights of that in light of what we're talking about here. Let's start with the requirement that's right in the rule and in the condition of approval for the 36-1 APD, that if the petitioner desires to seek a second horizontal well, they must come to the board for approval. So this is the second horizontal well, and we have to come to the board for approval. Okay? That's number one. Number two, he cites the temporary 640 rule. First of all, that clearly says that it does not establish correlative rights, that it's only meant for a well siting thing. And the point is the regulation also says that you can get an exception to that if you file for an exception location under 3-3. Okay? There's no need for them to file a petition for 3-3 because they could not get the consent of all the parties. You can't get the exception location. And it says if the board or if the division fails or denies that administrative approval, then you can come to the board for that, okay? I can't believe that you're saying that you can't come directly to the board for an exception location. You have the statutory authority to set locations of wells, whatever the circumstances are. And it would be ridiculous for us to have to come and file for something without the consent of everybody. The law is very clear that you do not have to do a futile act. So why would they come, given the fact this is a second horizontal well, and the fact that we couldn't get everybody's owners written consent on this because they were non-responsive or whatever, that you would have to come in front of the division to have them to deny it to come forward. Okay? Now, let's go to the correlative rights issue. As has been said many times today, it's common ownership between the north part of Section 36 and the south part of Section 25. It's the same owners. It's the same owners. So what you're talking about here is what is the percentage of sharing with that would occur, which Mr. Hopman has said initially, they're recognizing the fact that there may be some drainage for that, and they're willing to do that as an initial thing. When you come back and seek spacing, which I'll get to in a minute, that will set that proportionate share of that. More importantly, with correlative rights here, there are numerous protections already in place. First and foremost, this is a request for agency action that outlined everything that the petitioner is requesting for. It was received by every single owner in the whole area, and none of them objected. William Penn was the only one objected, and they've now withdrawn their objection. So if you're worried about Earlham College, they had the right to bring everything up that they were going to bring up in front of the board, and they didn't. That's a waiver. Okay? Second protection, they're still going to get their notice of opportunity to participate. They have to do that. They have to provide them an AFE, they have to provide them an opportunity to lease again, and they have to provide them a JOA if they want to participate as a working interest owner. If they don't, then once the well is drilled, once the date is determined, once a spacing order is in place, they would be compulsory pooled. So their correlative rights are being totally protected here, okay? Last point I want to make is going to the spacing issue, okay? He cites cowling, but he didn't cite the important part of cowling, okay? The important part of cowling says right off the bat, let me get to it here. When a successful exploratory well is initially drilled, it is ordinarily impossible to determine with any degree of precision what area the well drains or the characteristics and extent of the pool. Okay? You've heard plenty of testimony today about assumptions from the 36-1. It's got inconsistent production because of things that have occurred with it. There isn't sufficient logs. This well is an exploratory well. It is different than the 36-1. This is going to be a mile-long well. This isn't a short lateral well. Okay? There are a lot of characteristics with it. What we're asking is the permission to drill that well, get the data, and then come back and seek spacing. They're committed to that. That's part of the exception if you guys grant it. Okay? And then as far as that goes with the spacing part of it, I've just lost my train of thought. Hang on a second. Let me get it back. The data will help develop what the spacing would be. What happens if they incur problems in the drilling and the lateral doesn't go all the way to Section 25? or it ends up. That's exactly what happened with the 36-1. If you look at Exhibit D, you'll see they drilled it quite a long way, but they had to plug it back, so it's a very short, productive lateral that we're talking about here. That may be the case once they drill the well. So how can you come in and seek spacing when you don't even know physical characteristics of what the reservoir will be, how long it's actually going to be? Is it actually going to end up draining Section 25? So all of these matters are all outlined in my reply brief. This is why this is absolutely appropriate to come in front of the board. KGH has met every obligation it's had to meet under the regulation, and the board should grant this and allow this with the stipulated agreement by KGH that they will come back within 6 months after the well is drilled and completed and either provide the spacing at that time or explain why they don't have enough production data to actually set forth the appropriate drilling unit. So for those reasons, I think the division, with all due respect to Mr. Gruel here, they're off base. This is the way to do it. You can't, the other thing you got to remember here is too, with the common ownership, TK is a common law co-tenant with those parties. They can't be prohibited from drilling a well just because an owner doesn't consent necessarily. That is not the common law aspect of co-tenancy. You have the right. You have to account to that party, which they're clearly going to do, but it doesn't mean that they don't have the right to do that. So from that standpoint, what we're asking the board is to allow this well to be drilled, and then it will be in due course with spacing and appropriate protection of all their rights as we've outlined. So I thank you for the board's attention. And again, this is all outlined in the reply memorandum. If you've not had an opportunity to read it, I would ask that you please do so. Thank you.
We'll come back to you. But just right now, the board, any follow-up questions for
Yeah.
KGH?
For KGH, what is your plan on open hole logging on this, on a 36-2 well?
Our plans are to drill a pilot hole through the interval. We don't know where the bottom of the interval is yet right now. That's the good news. So we're going to drill a pilot hole and run a suite of logs, the FTC, CNL induction standard logs we'd expect.
And how large is the pilot hole?
8 3/4.
Oh.
Yes, Mr. Mayor.
So we haven't heard of a 50-foot setback before. Explain again why such a small setback being requested here.
Well, because we have leasehold on both sides that is common ownership, we're trying to figure out, we're still in the early stages of this exciting program. And so we're trying to figure out what is the best economics to get a mile lateral, close to a mile lateral if we can get there, in terms of the run based on rate of return for economics. And so we obviously a short lateral from the reserves but to home showed is not the way to go. And so we can, if it's consistent throughout, we can determine the thickness of the reservoir by drilling the pilot hole, going a mile, see what kind of production we have. Then we'll come back and we'll know a heck of a lot more a year from now than we're going to know right now.
So, I'm sorry. When you say common ownership across that section line, that means Earlham College, the ones that you have not been able to sign on, owns the same percentage on either side of that
Identical, yes.
line.
They just, once again, it's just non-responsive, or the latest response we had is no response, that we don't want to do anything. Don't even call us anymore.
But they
So
do own the same percentage
They
on
identical
either side of
percent,
the
yes,
line.
12.5% on both sides, yes.
Okay. Sorry, Mr. Church.
So would you remind me, who shares production on the 36-1? Is that a lease well as far as who shares the production on
Yes,
that?
that's a unit well within the Bonanza unit. Then Sitla has 100% of the royalty share. And then the interest owners outlined with my 83%, and they're just working their way down, sharing that percentile.
In the 36-1? So what I don't understand, if it's a 277-acre unit, but you're saying it's in the other field.
Mr. Church, if I can help explain, don't confuse a drilling unit with a state or federal exploratory unit, okay? That's an important difference here. It's not space, so there's no drilling unit for the well. It's part of a state-administered exploratory unit, just like a federal exploratory unit would be, okay? And without it being on it, I think the testimony Mr. Houtman said was, and Mr. Hone also said, it is a lease well. It's on the state lease, and it's not draining, according to Mr. Hone's best calculations, it's not draining anything but that state lease.
Okay, so only Sitla gets the royalty production?
Correct.
Okay, thank you.
One last question from me is, so well 36-1, it seems like it had a fair number of problems, right? The production's not maybe quite what you anticipated. You weren't able to log it. Is that a fair assessment? Was this a problem well in some ways, or was it by design that these?
It was initially by design as a monobore well, utilizing the log from the MAR 3-3H, where we anticipated to hit the bonanza horizon. The only surprise we had is that the reservoir, as said, as Mr. Winger testified, it's at least twice as thick as what we anticipated, which was a nice thing to have happen. The well production problem has been, this elevation is almost 7,000 feet. We were, for most of the winter, had over 3 feet of snow with 50-mile-an-hour winds, and our production had been, it's an understatement how difficult it's been to try and produce a well in this last winter we had. And so it's now, Mother Nature's finally letting us get caught up again, but we had roads, we couldn't access the locations except by snowmobile. We couldn't ship out any oil. It's been I'm looking forward to spring and summer.
So was the design of the well, and forgive me, I'm a hard rock geologist, was the design of the well where you weren't able to do, as comprehensive a logging program as is typically done because of those weather conditions, or was it because of the original design?
No, that was the original design.
That was
anticipating what we thought we would have in the state line in Colorado, utilizing that type well log to go into that in a monobore without having to run intermediate casing, and it's a cost. We're a very small company. And so in a perfect world, we would have run a core, but they're $1 billion, and we're a small company.
All right, it was an economy.
Yes.
Okay. Yes.
So does the Bonanza unit go through the center of Section 36, or all the state lands in the state-operated unit? Where is the dividing line between lands in the unit and lands outside the unit?
The Section 36, that partial section, except for the west half, northwest quarter, is 100% within the Sitla unit. That's the very southwestern corner of the unit. These are the lands that we're talking about are lands that are some fee lands within the exterior boundaries of the unit, but they're not committed to the unit.
So the fee lands are within the exterior boundary of the unit, but not committed.
That's correct. Once again, no response, not for lack of trying, 1,000 times. Yeah.
Thank you.
Okay, I'm curious about your term monobore. So did you set surface casing and no other casing, or how's this well, what's the mechanical integrity of this well look like? Or the wellbore sketch, or if you would.
Yeah, the monobore, the basic design is surface casing set, and then you just drill your main hole out from that surface pipe and through the curve and out to the end of your lateral. There is no intermediate casing run.
Okay, so you leave it all open hole?
Leave it all open hole. In this case, we set the casing deeper than we normally would, or the surface casing, I think, was set at about 2,000 feet rather than 1,000, and then drilled out to TD with I think it was Yeah, we ran 5.5 casings, so I think we drilled 8 3/4 hole all the way to TD.
Okay. Okay. But there's no, after the surface casing, there's no more casing? It's
No.
all open hole?
It's a technique they've used extensively in Colorado, DJ Basin and such, and it's being accepted and put to use outside of that area.
Okay, I'm confused because I'm getting two different signals.
There's production casing.
Oh,
in
there
the
is
hole.
production
Yeah.
casing? Okay,
Yeah.
okay,
Run to TD, back to surface.
okay. So you only have 2 strings of casing?
Correct.
On the whole well? Okay.
And if I may clarify another point, if it's all right, Mr. McDonald, I think you stated something about this well being drilled and then plugged back. That, if I'm not mistaken, that is not the case.
No, what I meant to show was, what I meant to say was Exhibit D shows it as a long lateral well, and the bottom of the hole is back.
Is actually, yeah,
Yes.
it's the shorter lateral.
Yes.
Yeah, that was a drafting error only. The well was drilled and
Right.
those
I
complications did
apologize
not
for that.
occur.
That's what I was trying to get at.
Yeah, it was a financial decision to make it a short lateral rather than a complication during drilling process.
Okay.
Thank you. Any more questions for KGH? Just trying to keep it a little organized. I want to make sure everyone gets a chance to speak. I guess we're going to come back to you and see if there's any more points you'd like to add or any responses you'd like to make to the discussions we just had. Division?
Yeah, just in rebuttal to what Mr. McDonald has raised, the important part of cowling is what Mr. McDonald said, that an exploratory well is, when you first go to drill an exploratory well, you don't have enough information. That's absolutely right. That's not the case here, though. We have, just on the other side of the border, right, roughly 900 feet from the existing well, we have a spaced area. Petitioner operates a well a 1/4 mile away with 10 years of data. We know what's going on here. We know the geology. And to the extent that there are missing pieces, it's because petitioner chose not to follow the regulations and the instructions in their APD for the 36-1 well. They were told, you need to come back in space if you want more wells in section 36. And they haven't done that. And when they spoke to the division before ever filing this, the division has consistently told them, you need to come back in space. But they haven't. With regards to the board's authority here, the board has obvious authority and jurisdiction over where to put wells. And to the extent that the board views Mr. McDonald's representation as accurate, we need a clarification on the interpretation of this rule in particular. Because the way that this rule is set out and we are interpreting it, it requires consent. Whether that comes before the board or whether that comes before the division, it requires consent. And that's because it says, if for any reason the division shall fail or refuse to approve such an exception. Well, such an exception is an exception that contains the required elements in the previous subparagraph. So if the board wants to interpret that to get an exception location through the board, consent is irrelevant, we need a clarification on this interpretation, because that kind of defies the plain reading of that regulation. And with that, we'll rest.
Any follow-up questions for the division from the board? Mr. McDonald, any closing statements?
No, I'll stick with what I said, but again, I respectfully disagree with Mr. Gruelle on that last point. The point is that the division has the administrative approval process if those requirements are met. It does not divest the board of its jurisdiction to address that issue, particularly when you file a request for agency action and the parties have been notified, had their rights, and you're being adjudicated in front of this with the board and with evidence, testimony, and hearing. So to sit there and say that the board does not have the authority to grant an exception location, to me, is a very inappropriate reading of the regulation.
Division.
Thank you. The division is not saying the board does not have authority. The division is saying the board has rules in place. When the division reads it, this is what the rules say. If the board wants to deviate from that, the division needs to understand better and get a clarification on that interpretation. The board's rules are essentially like a board decision, only more impactful because it's gone through the scrutiny of formal rulemaking. The board certainly has authority, but in no way is the division claiming the board has been divested of any sort of authority. The division is just looking at the board rules and trying to make sense of them. And the way that it makes sense is that when it says, if for any reason the division denies such an exception, referring to an exception that contains the required elements, including consent, then they can come before the board in this procedure. It's not what happened here. Just a closing statement. One of my favorite movies from childhood is Wizard of Oz. And in the ending scenes of Wizard of Oz, the Wizard of Oz says, pay no attention to the man behind the curtain. That's what's occurring here. Pay no attention to the statute that says you get one well draining from a common source of supply. Pay no attention to the rule that says one well per 640 acre. Pay no attention to setbacks that are 50 feet when the estimated drainage is 334 feet and there are unleased owners. Pay no attention to compulsory pooling, which is the proper procedure for dealing with recalcitrant owners. Pay no attention to anything that matters. Just let us do what we want. That's what's being asked here. We can't. We have to look behind the curtain. We need order, and we need procedures followed. That's why we have laws. That's why we have rules. And with that, we'll rest.
I have a question. Sorry.
No, you're just
Sorry.
okay. No, go ahead.
Does the division not recognize state-operated units? Do you only recognize federal-operated units?
That's a challenge.
If this is in a unit, my question is, usually spacing is suspended, and that probably needs to be done at the board level, but do you not recognize state-operated units?
So that's a challenge that's come before the board in the past. And if this entire area were contained within a state-operated unit, the division would have much less heartburn over what's being requested here, in particular because there wouldn't be unleased owners whose minerals could get drained from these really tiny setbacks.
But aren't those fee, at least the stuff in 36, isn't that included in the unit? It's just not committed to the unit.
Yes, but that, you have to treat it as if it was not in the unit, if
Okay.
it's not committed. That's the same
Gotcha.
way with the federal exploratory unit.
Gotcha. Thank you.
Okay, I guarantee you we are going to retire for consultation. And we will return as rapidly as we can. Thank you for your patience. Welcome back. We are back on the record. Division and Mr. McDonald, do you have something you could present to us from your discussions?
We have a stipulation, Mr. Chairman. The division and KGH have stipulated that the board approve the request with modifications as required under R 649-3-2 subparagraph 10. That's the one that requires board approval for any additional horizontal well in the same section. In addition, the board will be exercising its discretion under Rule R 649-2-1-2 to suspend application of Rule the 640-acre temporary rule under 649-3-2. KGH will also stipulate to having a 330-foot setback from the Section 25 section line instead of the 50 feet. And we will also stipulate to the fact that any proceeds attributable to Earlham College will be held in suspense pending resolution of their notice of opportunity to participate and their election made under that. Also, again, just to reiterate, as KGH agreed to originally, we will come back in front of the board within 6 months after completion of the 36-2 well to seek spacing, or if additional data is necessary, to provide that justification to the board.
Division, is that a fair summary of your discussions?
Yes, the division believes that those stipulations outlined, if approved by the board, would protect correlative rights as well as facilitate the maximum recovery available of the resource.
Thank you for that, and I think I can speak for the entire board. We appreciate you all working together on this to come to a logical conclusion. I believe we could entertain a motion to approve the stipulation.
I'll make a motion to approve the stipulation to the request for agency action as stated.
I'll second that.
Any last comments from the board? All those in favor say aye.
Aye.
Aye. Let the record show that was unanimous. And I believe that concludes our last item.
Mr. Chairman, do you want me to prepare the order? Okay.
Yes, please.
I will work with division and board counsel on that. And if also, if I may, on a personal note, I'd like to thank Mr. Hansen as well. It's been a pleasure to appear before you for the last 12 years, and especially appreciate your insights and your questions, which were excellent questions all the time. So, again, good luck with your retirement from the board.
Mr. McDonald, it's been a pleasure working with you.
And I would like to second that on a personal note. I've really enjoyed working with you, Chris.
It's been good to get to know you.
Is there a motion to adjourn the meeting today? All right, we are off the record. Thank you.